Unmuted. Hand over all the memos. We come tomorrow. Number 66. Yesterday's it's over. Yesterday's it's over, Mr. You file an application. Yesterday it's already signed, it is already released. Then you remove the made a mention yesterday itself. Moving it, mentioning it today. Must have mentioned at the end of the day at least. Lost it, file an application. Yes. Want it tomorrow? Please pass it on. There is, yes. Yeah. 75. What do you want? Just to learn from, please intimate the other side. Just to learn from you. Request to learn counsel for the petition. Yes. Yes, Mr. What? Number 60. The learned counsel for the petitioner submits the petitioner as accused is no more and seeks time to secure instructions. Stone? Yes, Mr.
40.3.
45.
41. 40.1, 40.2, 40.3. Connected matter.
Yes, what do you want? 2014. Sorry.
1 week plus.
Yes.
Number 27.
Number 27.
Friday, 27.
Ramesh GP.
Friday, 27.
2013, sorry.
Friday.
Sorry. Please come to this side. Come to this side. Please come to this side. Come to this side, mister. Come to the end. You should understand what the court is doing. They are standing in the line, so you should wait for your turn. Yes, you came just now, I saw. Yes, mister. Yes, ma'am. What do you want? request to learn counsel for the petition respond. Yes, Mr. 2018. Request to learn counsel for the petition respond. But 2014 ಎರಡೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ. Request to learn counsel for the petition. Objection. Request to learn counsel for the P. Request to learn counsel for the petition respond. ಯಾರಿಗೆ ಹೇಳ್ಕೊಡು? When you people will learn? When will you learn? When will you learn? Mister, I'm asking you, when will you learn? Huh? You can't wait for your turn, is it? He is also an advocate, mister. He is also waiting. His time is equally precious. You came late and you want your matter to be taken up early. Tell this. Yes, mister. What is the offense? What are the offenses? It will be taken up at 2:30. Official. We will take it up at 2:30. See number? Sorry, that is rejected. 40.3. That is rejected. Wait, madam, that's in the orders. Yes, lawyers on the VC.
My lord, serial number 59, my lords.
Number 59.
Please, my lords, 1 week time may be granted, my lords.
Request of learned counsel for the
Respondent, my lords.
respond. Yes, anybody else? Anybody else? There is. The letter addressed by the court is scheduled. Review of the destruction of the record in criminal appeal 128 of 2012. The learned counsel for the petitioner is directed to place on record a copy of the appeal as well as the copy of the appeal. Same order. Copy of the appeal, criminal appeal 159 of 2011.
Petitioner, my lord.
The appeal in criminal appeal 904 of 2011.
Petitioner, my lord.
Scottish a copy of the appeal.
Please, my lord. Not with report.
Copy for his act.
Please, my lord.
Because the appeal copies are destroyed, appeal file is destroyed.
Final note.
Appeal copy,
Please, my lord. A week's time, ma'am. Please.
The petitioner has filed IA 1/23 for extension of time to comply the order dated. 2022.
After 2 years, they're not paid any money.
25% of the.
They are doing 25%. 18% also is not paid during the trial stage. And 25% not paid the amount.
When will you deposit?
Not 25%, my lord.
You deposit, then only we'll consider releasing it.
Yeah.
You deposit the money, then only we'll consider granting in bail. Whatever it is. You deposit the order, the amount as or directed by this court. Only thereafter we'll consider releasing in on bail. Whatever it is, as per the order. IA 1 to extension of
Correct, not 1.5%, my lord.
to comply the order dated so and so. Stop. The learned counsel for the petitioner submits the petition number. Learned counsel for the petition of 2 submits that the petition number 2 is arrested pursuant to a warrant of arrest issued to execute the order of sentence. To execute the sentence ordered by the trial court. The learned counsel for the respondent opposes this application and submits that the petitioner has not deposited the amount before this court. He had also failed to deposit the amount as ordered by the trial court, and therefore no lenience be shown to the petitioners. Since this court has already passed an order suspending the sentence. 4/2/2022, subject to the petitioner depositing 25% within 4 weeks. It is appropriate that the time granted by this court is extended by another 2 weeks, within which, the amount as ordered by this court on 4/2/2022 shall be deposited. The question of grant of bail shall be considered only after the deposit is made.
It is a 10% that was not.
10% is before the trial court. Right, Eddie? Have they deposited the 10%? But what will you withdraw? That is your problem, Mr. The court, both the courts have held that you are bound to pay.
5 lakhs, people in the online runs. 55 lakhs, they are showing 50 lakhs. Cash transaction.
Both the courts have held against you. Both the courts have held against you. Must be something to it. Please deposit. You consider releasing in your bail only after you deposit. Yes, next.
Settlement out of court.
Learned counsel for the petitioner has filed a memo to withdraw the revision petition in view of the settlement of the dispute by the parties. Stop. Settlement ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಿದ್ದಾರೆ.
Respondent ಇದ್ದಾರೆ,
ಇಲ್ಲಿದ್ದಾರೆ.
ಹೊರಗಡೆ ಇದ್ದಾರೆ.
ಕರ್ಕೊಂಬನ್ನಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ನೀಡಿ ಅವ್ರ ಹೇಳಿ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಐ ಕನ್ಸಿಡರ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಸೈನ್ ಮಾಡಿ.
ತಗೊಂಬನ್ನಿ ಅದೆಲ್ಲ. ಸಾಕು. 2 weeks. 2 weeks. 2 weeks to comply the office. 2 weeks time is granted to complete.
Appeal my lord.
Counsel for the petitioner is convert petition to appeal. The memo is placed on record and revision petition is permitted to be converted into a criminal appeal. For statistical purposes, this revision petition is treated as closed.
Petitioner, my lord. Petitioner is conducting another court. Kindly pass out.
Maintainability, here maintain. Password. 2 weeks time is granted to do the needful. 2 weeks. Counsel for the petition submits to the office of justice are complied. Office is that verified. All offices are complied. Revision petitions are listed for admission. When you listed for admission, if you compared all the offices. If you compared all the office objections, you listed for admission and will consider the application for suspension. Next. Non-counsel for the petition submits to the petitioner is expired and therefore the proceedings have awaited. The petition is dismissed as abated. Any amount in deposit, 130. It is 130. Any amount in deposit is ordered to be released to the respondent. Number 12. What happened? Yes, madam.
Wherein they have put for action of ours, like, there is a mistake I did there. So far as the first the mistake, when the party.
No, but how can you auction this sale deed? It's a site which is meant.
324 में they have public action.
When will you execute the sale deed in this case? Please wait, madam. Don't. Draft sale deed bandilwa.
Apart from that, we were busy because ನಮ್ಮ side action getting.
I think if you are executing the sale deed, you take it.
This is in respect of Mandina.
Site number 322. 322 is yours. Site number 322. What about? Ninja
24.
24 sale deed. 24. Hand over a copy of the sale, draft sale deed. I will hand it over to the.
This is 22 I'm handing over. The other one I have sent it to my learned friend. This possible because not all targeted. They're not coming properly and we not but the letter we have given.
One of 23 is filed by the petitioner.
Kindly see this letter also.
No, please wait. IA 1 of 23 is filed by the petitioner for stay of the auction.
So far as 324 is concerned.
Yeah, 31/12 antiದೆ. What is the date of the auction?
2018.
May ದಿನಾಂಕ 16/1.
31/12 is the notification date. Date as 18/1 was the auction.
IA 1 of 23 is filed by the petitioner. In WP number 27534 of 2015. To stay the auction proposed by the respondent number 2. In respect of the site bearing number 324. So it is contended by the petitioner that this court had directed the respondent number 2 to convey the site number 324. However, the respondent number 2, instead of complying with the said order, has now proposed to auction site number 324. The learned counsel for the respondent number 2 submits that the auction notification was a mistake, as site number 323 was 323
Had to be option.
as site number 323 had to be auction. He submits that the auction of site number 324 was not conducted, was not held, and that the respondent number 2 will not auction site number 324. To stop. The learned counsel for the respondent number 2 has today handed over a copy of the draft sale deed to the learned counsel for the petitioner in respect of site number 324 and submits that the sale deed would be executed soon after it hears from the petitioner. Soon after the draft sale deed is approved by the petitioner. To stop. The submission is placed on record since it is stated by the learned counsel for the respondent number 2 that it has no intention to auction site number 324. IA 1 of 2023 is disposed of as is rejected rejected based on the submission made by the learned counsel for the respondent number 2. Second 12.1 almadi. Vallali, the learned counsel for the respondent number 2 has today handed over a draft of the sale deed to be executed in favor of the petitioner, conveying site number 322 as per the order passed by this court. Stop. Yes, madam, what is it you want to say? That is right. That is. No, they have to allot 40/60 to you, and they have. Yes,
We have given, how we have given the draft sale. So whatever.
Allah, but you have to give a CD certificate, correct emission certificate.
That time, of course, the authority, they have given the draft sale. Now it has to be approved. Can they approve them definitely? You have not 1 inch of.
Give a CD, you have to give a possession certificate.
Yes, all that will be given. Once the sale deed is approved, we will do it. 10 days time will be given and let them approve the authority.
The learned counsel for the petitioner, however, expressed concern as the respondent number 2 concern contending that the respondent number 2 has attempted to auction site number 324 by mentioning the measurement of site number 322. This is, however, disputed by the learned counsel for the respondent number 2, who submits that the petitioner would be allotted a site measuring 60 feet into 40 feet. Full stop. 40 feet soon after the draft sale deed is approved by the petitioner. So, in view of the aforesaid submission of the learned counsel for the respondent number 2, the concern expressed by the learned counsel for the petitioner may not deserve, not merit any consideration. So, however, soon after the draft sale deed is approved by the petitioner, the respondent number 2 shall ensure that a correct dimension certificate along with the possession certificate is handed over to the petitioner. Yes. Please verify the draft sale deed. If you have any difficulty, please let them know. They will correct the boundaries. They will correct the boundaries. And anyway, the matter is still before us. So therefore, we can still hold them responsible.
Second way is concerned.
Yes.
They have to.
Otherwise, we'll have to keep whoever is responsible present before the court. Do it, Saita. HCGP seeks time to ascertain whether the cost imposed by this court in terms of the order dated so and so is recovered from the concerned official or not. List on when do you want? When do you want it? Not Monday, madam. You do all those things. You hand over the draft sale deed. Let them take steps. In the meanwhile, let the government also recover the cost. Can this happen within 1 week? We're in India. List on? Okay. 6th February 2023. Yes. Condonation of delay. Any objection? HCGP. Condonation of delay. 169 days. What is the offense? Please challenge, madam. Correct, but charge sheet is filed. You mentioned in the charge sheet that file your further report. Then we reserve liberty to them to file a fresh application after the further report is filed. Suppose the petitioner is challenged. Sorry, IA 1 of 22 is filed for condonation delay from 169 days in filing the division petition. The learned HCGP does not seriously oppose condonation of delay. Hence, IA 1 of 22 is allowed and delay of 169 days in filing the division petition is condoned. Next para. The order settlement. This revision petition is filed. This revision petition under section 397 of CRPC is filed challenging the judgment is for the order dated 7/3/2022 passed by the 12th Additional District and Sessions Court at Hassan in SC number 104 of 2017, by which an application filed by the petitioner under section 227 CRPC was rejected. Full stop. Next paragraph. The petitioner was accused number 3. Accused number 3 was charged for the offences punishable under section 498, 304B, dealt with section 34 of IPC and section 4 of the Dowry Prohibition Act. Stop. The accused number 3 filed an application seeking discharge on the ground that the prosecution, on the ground of the material placed by the prosecution page 77. Page 70, no, 77. You know what I mean? Containing that did not justify any charge against the petitioner for the offence punishable under section 498A, read with section 498A, 304B APC. For 498A, 304B, read with section 34 of IPC. Section 3 of the Dowry Prohibition Act. Full stop. The learned HCGP submits that a death note of the deceased was recovered. The death note of the deceased was produced by GP Kumar Yeshnes CW. CW 2018. CW4 was produced by CW4, and that the same was forwarded to the handwriting expert. And that the investigating officer had reserved his right to submit a further report. Full stop. The learned HCGP therefore submitted that unless the further report is filed before court, our question of entertaining the application filed by the petitioner does not arise. A perusal of the charge sheet thus disclose that the investigating officer had pointed out that the death note of the deceased was produced by CW4 on 22/3/2017, and that the same is sent to the handwriting expert for forensic examination. Full stop. He had also reserved his right to file a further report. Stop in there. In that view of the matter, as rightly contended by the learned HCGP, the application filed by the petitioner for discharge cannot be considered at this preliminary stage. That view of the matter, this revision petition lacks merit and is dismissed. However, liberty is reserved to the petitioner to seek discharge after the final report is filed by the investigating officer. Well, it was passed on what date?
Right, well, Mela.
Here, 1 of 23 is filed by the land council for the petitioner seeking extension of time to deposit. Extension of time to comply the order dated 12/12/2022. Stop. Considering the cost shown for the extension of time, IA 1 of 2022-23 is allowed, and the time to deposit is time to comply the order dated 12/12/2022 is extended by a period of 1 week. Now, date of receipt the date of receipt of the copy of this order. It is made clear that if the amount is not deposited, the respondent is at liberty to execute the order of sentence in accordance with
Today, if it is handover, the regular handover, tomorrow I will.
this. File a memo to release the copy.
Yes,
IA 2 of 23 for recalling the order taken. What is this? IA 2 of 23, yaar. Who has filed this IA 2 of 23? ಇಲ್ಲ ನೀವೇ ಹಾಕಿರೋದು IA 2 of 2023 would be considered later ಅಂತೀರ ಮಾಡೋದು. Yes. ಹೇಳಿ ಏನು ಅಂತ. You have filed the application. Yes, sir.
आपके बाद considered representation. Very considered.
Yes. What is annexure B?
It will be it's a case identity. First part, element of compensation.
And that is, what is this annexure C1, page 91? ಓದಿ ಅದೇನು ಹೇಳ್ತಾನೆ ಸೈಯದ್ ಮಾಜರ್ ಅಜರ್ ಓದಿ ಏನು Yes.
ಪ್ರಮುಖ ಭಾಗವಾಗಿ ಈ
This is not in dispute. This document is not in dispute. Who is this Imtiaz Farida? And what is your right to claim compensation?
See, petitioner mother Nisa, 1 ಸೈಟ್ ತಗೊಳ್ತಾರೆ. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ. ಅದರೊಳಗೆ 3 ಜನ ಹೆಣ್ಮಕ್ಳು 3 ಸೈಟ್ ಅನ್ನ ಮಾಡಿ 3 ಜನ ಮಕ್ಕಳಿಗೆ ಕೊಡ್ತಾರೆ. ಇವರು ಫರೀದಾಬಾದ್ನಿಂದ ಜಿಪಿ ಆಗಿ ಕೇಸು ನಡೆಸ್ತಾರೆ ಜೊತೆಯಲ್ಲಿ. ಆ ನಂತರ ಇವರಿಗೆ ಗಿಫ್ಟ್ ಮುಖಾಂತರ ಅದರ ಮಾಲೀಕತ್ವ ಇವರಿಗೆ ಬರುತ್ತೆ. ಆ ಸಮಯದಲ್ಲಿ ಈ 97 ವ್ಯಾಲ್ಯೂ ಪೊಲೀಸರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ, ಇದಕ್ಕೂ ಆಯುಕ್ತರಿಗೂ ಕೊಡ್ತಾರೆ. ಈ ರೀತಿ ನನ್ನ ಜಾಗಕ್ಕೆ ನುಗ್ತಾ ಇದ್ದಾರೆ, ನಾನು ಫೌಂಡೇಶನ್ ಹಾಕಿದ್ದೀನಿ, ಆದ್ರೂ ಇವ್ರು ಬಿಡ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟು ಇದು ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜೆಕ್ಷನ್ ಪರ್ಮನೆಂಟಿಂಗ್ ಇರ್ತದೆ, ಆ ಎರಡನ್ನೂ ಅಲೋ ಮಾಡುತ್ತೆ. Decree is it?
What is the date of the gift deed?
Gift deed. Yes. 2008. 2008. This is Petitioner suit. That was filed in 1997. It has been significantly affirmed as to the significant defend that defendants, that is private individuals, who are defendant 1 to 10, they have claimed that it is a road for the last 35 years. They have also, they have removed the foundation of property, that is the content of the data.
You are also a party.
I am a party.
Have you contested? What form? If you say that the road is formed by you.
No, we have not formed any road. We have operation.
What is it?
It is a
You have asphalted it, you have maintained it.
yes, in fact, it is within our limits.
So without the road being vested in the corporation, how would you do it?
Yes, I understand. Without the road being within the limits of the not only not in the there.
Yes? Would you say it is necessarily vested in the government? It should be reserved. It will land dominate. Survey manual is there. Survey manual is there. Yes, sir.
And in case of the matter, that is going to say such thing. If it is a beach or land, or it has been in use. Right. This is what I am saying. The very avastha of the way is,
So there was no road actually then.
Most specific common party in the food.
Yes.
It was just a common party, means hard.
Yes.
No, the defendants, this individual defendants, they have by written statement.
Statement of objections, sir. Page number 24.
And this court is very well. The system of the represented
Page number 24.
More than second paragraph. Body can support I have observed
Well, how do you justify this? How do you justify the resolution? Then what steps you taken against the persons who brought about this resolution? ನೀವೇ ತಗೋಬೇಕಲ್ವಾ? Sure, R1.
This main road that is called the road is not the property. Now the dispute is which connects because better from a Uganda. But there also is a place 25. After a country can be seen. This is just is joint on to that.
No, you file an affidavit that you are not acquired this land, number one. File an affidavit that this land is not vested in the corporation. File an affidavit.
I cannot say that the land has not been vested.
Then, if it is vested in the corporation.
As far as the corporation is concerned, corporation has not taken any action either for parliament or.
You have asphalted the road. You have asphalted the road, you have maintained the road. Right? Without vesting, how can you do it? Therefore, have you assessed this particular property? If it is assessed, then we can understand. If it is not assessed, because it is a road according to you, as per your resolution.
When the property is that particular area can is already a road. There is no question of assessment.
Yes.
I cannot assess. So therefore, this is one aspect. If the and it is executed again only.
Favor of? Who is this man? Who is the petitioner? Abdul Ghafoor. Ah.
In respect of
ಈ ಹಿಂದೆ ನಜೀರುನಿಸಾ ಅವರ ಜಾಗ ಎಂದಿದ್ದು ಹಾಲಿ ರಸ್ತೆ ಆಗಿರುತ್ತೆ. No, but what should happen to the degree passed to the Shalpo 50 years?
It is open to you to execute the degree.
Right. You are a party to this decree. Let me complete. You are a party to this decree. Petitioner's principal is declared as the owner of this property. If this is a road, according to you, and if this is a site according to the petitioner, let him take recourse to law, whatever remedy that he has got. He will close the road then. Based on this decree, he will close. To the honest person.
Has been saying that in the year 1997, please turn to page 94.
Yes, Mr. What is there to show that this property is acquired?
Property is acquired, one thing is, ಅದನ್ನ acquire ಮಾಡಿದಂಗೆ 97 ಅಲ್ಲಿ he has complained.
What is there to show that this is acquired by the corporation?
Acquired and formed, and we have inquired with the Ayuntha Commissioner, and after giving all the things to them, even the Ayuntha office also inquired about for whom the tender has been in, who formed
on that. They're not on that. What is there to show that this land which you claim is acquired by the corporation?
They have forcibly acquired and formed the road.
Therefore,
What? Page 13, which I have given the document.
page 13.
13. It is not been acquired. Page number 30. ಇದಕ್ಕೆ ಭೂಮಾಲೀಕರು ಈಗಾಗಲೇ ಅಂದ್ರೆ ಮೀಟಿಂಗ್ ಇಸ್ ಕಾಲ್ಡ್ ಬೈ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಡಿಸೈಡೆಡ್ ಆನ್ ದಿ ಡಿಸಿ ಅದರೊಳಗೆ ಎಲ್ಲರೂ ಬರ್ತಾರೆ ಇದಕ್ಕೆ ಭೂಮಾಲೀಕರು ಈಗಾಗಲೇ ತಮ್ಮ ಪ್ರದೇಶವನ್ನು ಬಳಸಿಕೊಂಡು ರಸ್ತೆ ನಿರ್ಮಾಣದ ಬಗ್ಗೆ ಪರಿಹಾರ ಕೋರಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ವಿಚಾರಣೆ ನಡೆಸಿ ದಿನಾಂಕ 35/30/2020 ಆಯುಕ್ತರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಶಿವಮೊಗ್ಗ ಅವರ ಸಮ್ಮುಖದಲ್ಲಿ ಈ ವಿಷಯ ಸಂಖ್ಯೆ 115ರಲ್ಲಿ ಪರಿಷತ್ ಸಭೆಯಲ್ಲಿ ನಿರ್ಣಯಿಸಲಾದಂತೆ ಮಹಾನಗರ ಪಾಲಿಕೆಯ ಕಾಯ್ದೆ 1976 ಬದಲಿ ನಿವೇಶನ ಕೊಡಲು ಮತ್ತು ಬಿಡಿ ನಿವೇಶನ ಕೊಡಲು ಅವಕಾಶವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಅದಕ್ಕೆ ಪರ್ಯಾಯ ಮಾರ್ಗವೆಂದರೆ ಈ ಭೂಮಾಲೀಕರಿಗೆ ಪರಿಹಾರ ಕೊಡುವುದಾಗಿರುತ್ತದೆ ಎಂದು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಪರಿಹಾರ ನಿಗದಿಪಡಿಸಿದ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡಲ್ಲಿ ತುಂಬಾ ವಿಳಂಬವಾಗುವ ಸಾಧ್ಯತೆ ಇದ್ದು ಭೂ ಸ್ವಾಧೀನ ಪರಿಹಾರ ನಡೆಸಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡಲ್ಲಿ ವಿಳಂಬವಾಗುವ ಸಾಧ್ಯತೆ.
What is this that you are reading? This is a price violation committee.
Yes.
After the requisition was disposed of.
ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಇದನ್ನು ಮಾಡಿರುವಂತ
What is there to show that this land is?
ಡೈರೆಕ್ಷನ್
What is there to show that this land was acquired by the corporation?
ಅಕ್ವೈರ್ ಮಾಡಿ
ಅದಕ್ಕೇನಿಲ್ಲ.
ಲೀಗಲ್ ಆಗಿ
If it's a private layout,
ಹೌದು
if it's a private layout,
ಹೌದು
how do you hold the corporation responsible for payment of compensation?
ಎನ್ಕ್ರೋಚ್ಡ್ ಅಂಡ್ ಫಾರ್ಮ್ ದಿ ರೂಲ್.
Yes, a question of encroaching. It's a private layout. You have to access the main road. So therefore you have provided a road. It's a private layout.
Yes.
If it's a private layout, then you are bound to provide access to all the sites formed. And this access has to open into the main road formed by the corporation. So where's the question of acquisition? You have given it up to the corporation.
We are not saying they have acquired, but they illegally formed the place. That is what we
Who
are
has
saying.
formed the road, sir? Who has formed the road?
Municipality, not
What is that?
municipality.
What is that to show that they have formed the road?
They have formed the thing. I will
What
read
is
this.
there to show that they have formed the road? Formation of the road, you proof anything?
This is an admit ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Proceedings sir.
ಏನಂತ?
ಇದು ನಾನು ಓದ್ತೀನಿ ದಯಮಾಡಿ ಕೇಳಿ. ಈ ಬಗ್ಗೆ ಫಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 12 ಈ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಶಿವಮೊಗ್ಗ ಅವರಿಂದ ನಿರ್ದೇಶನ ದಿನಾಂಕ 29/7/2022ರಲ್ಲಿ ಸದರಿ ಪ್ರಸ್ತಾವನೆ ಕುರಿತು ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಲಾದಂತೆ ಹಾಗೂ ದಿನಾಂಕ 18/8/2022ರಂದು ಧನ ನಿರ್ಧಾರಣಾ ಸಭೆ ಕರೆಯಲು ನಿರ್ಧರಿಸಿರುವಂತೆ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಲು ಅಗತ್ಯ ಸಲ್ಲಿಸಲಾದ ದಾಖಲೆಗಳ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿದ ಇಲಾಖೆಗಳಿಗೆ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ದಿನಾಂಕ 8/8/2022ರಂದು ಪತ್ರ ವ್ಯವಹಾರ ಮಾಡಿರುವ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಲಾಗಿರುತ್ತದೆ. ಹಿರಿಯ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳು ಶಿವಮೊಗ್ಗದವರು ಸಲ್ಲಿಸಿರುವ ಮಂಡಳಿ ಗ್ರಾಮದ SRO ಮೌಲ್ಯಮಾಪನ ಸಲ್ಲಿಸಿರುವಂತೆ ಸದರಿ ಮಂಡಳಿ ಗ್ರಾಮದ ಮಾರ್ಗಸೂಚಿ ದರದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವಂತೆ 0.05 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದವರೆಗಿನ ಜಮೀನಿಗೆ ಬ್ರಾಕೆಟಲ್ಲಿ 0.05 ಗುಂಟೆ ಸೇರಿದಂತೆ ಸಂಬಂಧಿಸಿದ ಆಯಾ ಪ್ರದೇಶದ ನಿವೇಶನ ದರ ಅಥವಾ ಆಯಾ ಕೃಷಿ ಜಮೀನಿನ ದರ ಎಕರೆ ದರವನ್ನು ಮೀಟರಿಗೆ ಬರುವ ದರ ಯಾವುದು ಹೆಚ್ಚು ಅದನ್ನು ಅಳವಡಿಸತಕ್ಕದ್ದು ಎಂದು ಅನುಬಂಧ ವರ್ಗದಲ್ಲಿ ಸಮರ್ಥಿಸಲಾಗಿರುವ ಪಟ್ಟಿಯನ್ನು ಸಲ್ಲಿಸಿ ಸದರಿ ಸ್ವಾಧೀನ ಪ್ರದೇಶವು 0.05 ಗಂಟೆ ಒಳಗೆ ಅಂದರೆ 0.01 ಗಂಟೆ 0.05 ಆಣೆ ಪ್ರದೇಶವಾಗಿರುವುದರಿಂದ ಇದನ್ನು ಅನುಬಂಧ 1ರ ಕೋಷ್ಟಕದಲ್ಲಿ ವಿವರಿಸಿರುವಂತೆ ಸದರಿ ಪ್ರದೇಶಕ್ಕೆ ದರ ನಿಗದಿಪಡಿಸಬಹುದಾಗಿದೆ ಎಂದು ವಿವರಿಸಿರುತ್ತಾರೆ. ಏಕೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಭೂಮಾಲೀಕರೊಂದಿಗೆ ಚರ್ಚಿಸುತ್ತಾ ತಮ್ಮ ಪ್ರದೇಶವು ಭೂ ಪರಿವರ್ತನೆಯಾಗದ ಪ್ರದೇಶವಾಗಿದ್ದು ಇದಕ್ಕೆ ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳು ನೀಡುವ ಮಾರ್ಗಸೂಚಿ ದರದಂತೆ ದರ ನಿಗದಿಪಡಿಸಿ ತಮಗೆ ಪಾವತಿಸುವ ಬಗ್ಗೆ ತಮ್ಮ ಆಕ್ಷೇಪಣೆಗಳೇನಾದರೂ ಇದ್ದಲ್ಲಿ ವ್ಯಕ್ತಪಡಿಸುವುದಾಗಿದೆ ಎಂದು ವಿವರಿಸಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಭೂಮಾಲೀಕರು ಸದರಿ 26/70 ನನ್ನ ತಂಗಿ ಅಂದರೆ ಇತಿಹಾಸ ಸರಿದಾ ಬಾಳುವ ಇವರು ನನಗೆ ಗಿಫ್ಟ್ ಮುಖಾಂತರ 2008ರಂದು 17/10/2008ರಂದು ನೋಂದಾಯಿತವಲ್ಲದ ಪತ್ರ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆಂದು ಪ್ರಸ್ತುತ ತಮ್ಮ ತಂಗಿಯ ಹೆಸರಿನಲ್ಲಿ ಪಹಣಿ ದಾಖಲೆಯಲ್ಲಿ ಖಾತೆಯೇ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ವಿವರಿಸುತ್ತಾರೆ. ಆದಾಗ್ಯೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಅಧೀಕ್ಷತೆ ಕ್ರಮ ವಹಿಸಲು ಕೂಡಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಭೂಮಾಲೀಕರು ಈಗಾಗಲೇ ತಮ್ಮ ಪ್ರದೇಶವನ್ನು ಬಳಸಿಕೊಂಡು ರಸ್ತೆ ನಿರ್ಮಾಣ ಭೂಮಾಲೀಕರು
This is for the valuation, asserting the value. I'm not on that. What is there to show?
The thing is,
Please listen to me, sir.
Really?
Please listen to me, sir, first. What is there to show? This property was acquired by the corporation for the purpose of formation of a layout. Huh? ಅದಕ್ಕೆ ದಾಖಲೆ ಇಲ್ಲ.
ಅದು ಪೇಜ್ ನಂಬರ್ 74 74 of the main.
Yes.
ಅದರೊಳಗೆ ಖಂಡಿಕೆ 48 ಪ್ರಕಾರ ಅರ್ಜಿದಾರರು 163 ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಪ್ರತಿಯನ್ನು ಬರೀ ನ್ಯಾಯಾಲಯದ ಆಶಯದಂತೆ ರಾಜ್ಯಗಳಾದ ಶ್ರೀಮತಿ ಇಂತಿಯಾಜ್ ಫರೀದಾ ಖಾನ್ ಅವರಿಂದ ಜಿಪಿಎ ಶ್ರೀ ಸೈಯದ್ ಮಜರ್ ಬಿನ್ ಸೈಯದ್ ಕಪೂರ್ ಅವರು ಸರ್ವೆ ನಂಬರ್ 167/2 ಸ್ಟೇಟ್ ನಂಬರ್ 24 ಪಶ್ಚಿಮ ಭಾಗದ 26 ನಿಮಿಷದ ಮಾಲೀಕರು ಎಂದು ಘೋಷಿಸಿದ್ದಾರೆ ಹಾಗೂ ಸತ್ತಿನವರೆಗೆ ಯಾರು ಪ್ರವೇಶಿಸಬಾರದು ಆದೇಶಿಸಲಾಗಿದೆ. ಅಲ್ಲಿ ಟಿಪ್ಪು ನಗರದ 5ನೇ ರಸ್ತೆಗೆ ಡಾಂಬರೀಕರಣ ಆಗಿರುತ್ತದೆ ಹಾಗೂ ಟಿಪ್ಪು ನಗರದ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಬಂದು ತೀರುವ ಕಾರಣ ಸಾರ್ವಜನಿಕರಿಂದ ಅಗತ್ಯ ಇರುವ ರಸ್ತೆಯಾಗಿರುತ್ತದೆ. ಖಂಡಿಕೆ 26.1 ರಲ್ಲಿ ಹೇಳಿರುವಂತೆ ಸದಸ್ಯರು ಅಧಿಕಾರಿ ಇಲ್ಲವೇ ಎಂಬ ಬಗ್ಗೆ ಸ್ಥಳದ ನಕ್ಷೆ, ಚಕ್ಕುಬಂದಿ ಹಾಗೂ ರೇಖಾಂಶದೊಂದಿಗೆ ಸಲ್ಲಿಸುತ್ತಾ ಜಾಗದ ಸರ್ವೆ ಮಾಡಿಸಲು ತಿಳಿಸಿರುತ್ತಾರೆ.
Do one thing, you please close your property, enclose your property. If you got a declaration of your title, and if there is no document to show that the corporation has acquired it, you enclose it by a compound wall. Compound ಹಾಕೊಳ್ಳಿ. Do whatever you want. But unless you show that this property was acquired by the corporation, you are not entitled to any compensation.
The institution itself ಸರ್ವೆ ಮಾಡಿದಾರಲ್ಲ, ನಕ್ಷೆ ಮಾಡಿ ಅವ್ರ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲೇ ಇರುವಂತ ಜನಗಳು ಅದನ್ನ ಸರ್ವೆ ಮಾಡಿ ಹೌದು ಇದನ್ನು ಬಡಿಸಿದ್ದು ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. That is what I am going to read now. ವರದಿ ನೀಡುವಂತೆ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯ ನಿಬಂಧಕರು ನಗರ ಆಸ್ತಿ ಮಾಪನ ಇಲಾಖೆ ಕುರಿತರ ಮೇರೆಗೆ ಸ್ಥಳೀಯ ಕಚೇರಿ ಭೂಮಾಪನ ಪ್ರಸ್ತಾಪಿತ ಜಾಗದ ಅಳತೆ ಕಾರ್ಯ ಕೈಗೊಂಡು ನಕ್ಷೆಯಲ್ಲಿ ನೀಡುವ ವರದಿಯಲ್ಲಿ 162/2 ಪ್ರದೇಶವು ಅರ್ಜಿದಾರ ಮಜರ್ ಬಿನ್ ಸೈಯದ್ ಅಬ್ದುಲ್ ಗವರ್ ಅವರ ಒಡೆತನಕ್ಕೆ ಪ್ರದೇಶವಾಗಿರುವುದಾಗಿ ಸದರಿ ಜಾಗದಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ರಸ್ತೆ ಹಾದು ಹೋಗಿರುವುದಾಗಿ ನಮ್ಮ ಅರ್ಜಿ ಸಂಖ್ಯೆ ದಿನಾಂಕ 11/6/2019 ಪತ್ರಕ್ಕೆ ಅದು ನಕ್ಷೆ ADLR ಕಳಿಸಿ ಎಲ್ಲದನ್ನು ಮಾಡಿ ಮತ್ತು ಅದು ರಸ್ತೆ ಅದರ ಮೇಲೆ ಹಾದು ಹೋಗಿದೆ ಅನ್ನೋದನ್ನು ಅವರೇ ಹೇಳ್ತಾರೆ. ಇದು ಅವರೇ ಮಾಡಿಸಿರುವಂತದ್ದು. ADLR ಕಳಿಸಿ ಅದರ ನಕ್ಷೆ ಎಷ್ಟು ಹೋಗಿದೆ, ಎಕ್ಸಾಕ್ಟ್ ಎಷ್ಟು ನಾವು ತಗೊಂಡಿದೀವಿ, ಎಷ್ಟು ತಗೊಳ್ಳಿಲ್ಲ ಅನ್ನೋದನ್ನ ಕ್ಲೀನಾಗಿ ಅವರು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ ಎ ಕಾರ್ಪೊರೇಷನ್ ಪೋರ್ಟಲ್ ಇಂದ ತಗೊಂಡಿರುವಂತದ್ದು ಡಾಕ್ಯುಮೆಂಟ್.
Page number 78,
74.
74.
Last but one line.
Yes, ಯಾವ್ದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದು?
ಇದು ಕಾರ್ಪೊರೇಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಕಾರ್ಪೊರೇಷನ್ ಇದು ಪೋರ್ಟಲ್ ಇರುವಂತದ್ದು. ಅದನ್ನ ADLR ಕಳಿಸಿ ನಾವು ನಕ್ಷೆ ತಯಾರಿಸಿ ಹೌದು ಅಲ್ಲ ಅಂತ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಅದನ್ನು ರೆಡಿ ಮಾಡಿರುವಂತದ್ದು. ಹಾಗೆ ಅದು ಪೋರ್ಟಲ್ ತಗೊಂಡು ನಂತರ ಮತ್ತೆ ಮಾಲೀಕತ್ವವನ್ನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆಯವರು ನಿರ್ಮಿಸಿದ ರಸ್ತೆ ಹಾದು ಹೋಗಿರುವುದಾಗಿ ಪತ್ರಕ್ಕೆ ಲಗತ್ತುಪಡಿಸಿದ ಸರ್ವೆ ನಕ್ಷೆ ಮತ್ತು ವರದಿಗಳಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ
ಸ್ಥಳದ ನಕ್ಷೆ, ಚಕ್ಕುಬಂದಿ, ರೇಖಾಂಶದೊಂದಿಗೆ
ಎದುರಿ ಜಾಗದಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಮಹಾನಗರ ಪಾಲಿಕೆಯು ನಿರ್ಮಿಸಿದ ರಸ್ತೆ ಹಾದು ಹೋಗಿರುವುದಾಗಿ ಸರ್ವೆ ನಕ್ಷೆ ಮತ್ತು ವರದಿಯೊಂದಿಗೆ ಸಲ್ಲಿಸಿದ ನಗರ ಆಸ್ತಿ ಮಾಪನ ಎಸ್
ಇದು ಅವ್ರ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅವ್ರು.
ಎಲ್ಲ ಇದೆಯಲ್ಲ, ಏನು ನೀವೆಲ್ಲ ಮಾಡಿದ್ದೀರಾ?
Page number 64.
ಆಯ್ತು, ಪ್ಲೀಸ್ ಫೈಂಡ್ ಔಟ್ ದಿ ಸೇಲ್ ಡೀಡ್ಸ್. ಈಗ ಈ ಸೈಟ್ಸ್ ಇದಾವಲ್ಲ, ಸೈಟ್ಸ್ ಇದೆಯಲ್ಲ, ಈ ಸೈಟ್ಸ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Now that you have passed a resolution, ನಿಮ್ಮ ರೆಸಲ್ಯೂಷನ್ ಸರ್ ಅದು. ಮತ್ತೆ then you should undo your resolution. Have they withdrawn the resolution?
Resolution does not indicate the document executed by the petitioner himself prior to the so-called date of this. Even prior to the so-called date of this, up to 2008, I do not know. It's not a registered document. The genuineness of it is doubtful. Right, sir? The genuineness of that document is a document.
I think we are not concerned about the document.
I find one way. Overall, I am going to repeat. Yes, kindly find. Information that is going to become a
Yes, page number.
Let the corporation decide all this. Let them consider. The corporation decide all
The
this.
thing is, they have admitted. It's ಅವರೇ ಮಾಡಿರೋದು. ನೋಡಿ, page number 64. Page number 64. Page number 6. But at least note ಅಂದ್ರೆ it is also part of your record. Page number 64. 64. ಅಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಸಿಟಿ ಕಾರ್ಪೊರೇಷನ್ ಕೋರ್ಟ್ ಪಬ್ಲಿಕ್ ಕೋರ್ಟ್ ಈ ಕೇಸ್ ಇದು. ಈ ಕಂಪ್ಲೀಟ್ ಈ ಕೇಸ್ ಇಂದು ಕಂಪ್ಲೀಟ್ ಕೋರ್ಟ್ ಅದರ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಹಾಕಿರುವಂತದ್ದು. ಇದು ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ್ದಾರೆ, ಗಡಿಗಳನ್ನು ಗುರುತಿಸಿದ್ದಾರೆ, ನಕ್ಷೆ ತಯಾರು ಮಾಡಿದ್ದಾರೆ, ಮತ್ತು ಎಷ್ಟು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಬಂದಿದೆ ರೋಡಿಗೆ ಅನ್ನೋದನ್ನು ಕೂಡ ಮಾಡಿದೆ. ಇದು ಯಾರು ಮಾಡಿದ್ದು? ಕಾರ್ಪೊರೇಷನ್ ಮಾಡಿಸಿದ್ದಾರೆ. ಅದು ನೀವೇ ಮತ್ತೆ ಅವ್ರದ್ದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದು ಪೇಜ್ ನಂಬರ್ 12 ನೋಡಿ ಸ್ವಾಮಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 12. ಇದು ಅದರೊಳಗೆ ಶುದ್ಧ ಸ್ಥಿರ ಸತ್ಯ ಶುದ್ಧ ತ್ರಯಪತ್ರ. ಅದು ಸೈಯದ್ ಮದರ್ ಸಣ್ಣ ಸೈಯದ್ ಕಲೀಂ ಅವರಿಗೆ ಹೊರತು ಸೈಯದ್ he has got 3 sisters. ಅದರೊಳಗೆ ಫರೀದಾ ಬಾನು ಅನ್ನೋದು ಒಂದು ಸಿಸ್ಟರ್. ಫರೀದಾ ಬಾನು ಇಸ್ ಡಿಫರೆಂಟ್. ಫರೀದಾ ಬಾನು ಇಸ್ ಡಿಫರೆಂಟ್. ಅವರಿಂದ ಜಿಪಿ ತಗೊಂಡು ಇವರು ಪಬ್ಲಿಕ್ ಮಾಡ್ತಾರೆ. ಆದ್ರೆ ಇಲ್ಲಿ ಸೈಯದ್ ಮದರ್ ಮತ್ತು ಸಣ್ಣ ಸೈಯದ್ ಕಲೀಂ ಇವರಲ್ಲ, ಸೈಯದ್ ಗಫೂರ್ ಇವ್ರ ತಂದೆ ಹೆಸರು. ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 12 ಆಮೇಲೆ ಇದು ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲಿ ನೋಡಿ ಸರ್ 20.
When did this lady purchase?
This lady purchased ಇಲ್ಲಿ
Adeli the same.
ಇಲ್ಲಿ
Please show that change. You place on record that said it.
ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 21 ಮೇನ್ ತೀರ್ಪಿನಲ್ಲಿ ಇದೆ. ತೀರ್ಪಿನಲ್ಲಿ ಇದೆ.
But I want to see the sale deed itself. Please produce it. Counsel for the petitioner is directed to place on record the sale deed and sale deed by which, the predecessor of the petitioner purchased the site in question. List on when do you want it? Whenever you want. When do you want? Let us see. Yes. When will you produce?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಾಡಿ.
Come on, wait. First. Model granted at least extend to the next state of the. Sale deed, if she has got a larger property, the sale deed, if she has got a larger property, then obviously this property must have been acquired. Let us see. Produce model. You may see, because it was admitted by you or maybe a colleague that the resolution was passed, the court has taken into consideration that resolution. The first thing that you must have done is you must have undone that resolution. Even if the resolution is site ಕೊಡಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಅದೇ ದುಡ್ಡು ಕೊಡ್ಬೋದು, ಅದಕ್ಕೆ ಪ್ರೈಸ್ ಮಾರ್ಕೆಟಿಂಗ್ ಪ್ರೈಸ್ ಇವ್ಯಾಲ್ಯೂಯೇಷನ್ ಕಮಿಟಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿ. You must have undone that resolution.
But now, even before they are both from their family. And then they started touching.
ಫಿಕ್ಸೇಷನ್ ಕಮಿಟಿ ಅದು ನಿರ್ಧಾರ ಮಾಡಿದ್ಮೇಲೆ ತಹಶೀಲ್ದಾರು AC DC ಆಯುಕ್ತರು ಅವರು ಕೂಡ ಇದಕ್ಕೆ ಸಹಿ ಮಾಡಿದ್ದಾರೆ.
Because of the court order, they have to complete. You are also filed a contempt petition.
Yes.
So what will they do? Yes, list on 31st.
Yes, madam. I'm for the petitioner.
Venkatesh or Bhagat?
Yes, madam. I'm for the petitioner.
Yes, offense.
Your lordship have heard 279, 337, 304 my lord. Yesterday, lordship have heard this matter. All have turned hostile. No corroborative evidence.
Yes, Mr. They delayed cross-examination. Yes. Just read the judgment of the trial. What does it say? How does it consider this? Okay, Krishna Kumar. You're missing this word set in I think you are trying to jump to the next word. Don't do that. It appears that during this period, something fishy has taken place between these witnesses and the accused. And as such, at the instance of accused, they are deposing false before this court. Yes. Another very important fact which falsifies.
PW1 is also the first the contention of of not drive of the and you have arranged given the representation before here of this clearly shows that given the evidence given in my Guru Bugare has clearly stated that he has raised the motion.
Why should the accused challenge the FIR? Why should the accused challenge the charge sheet?
What is very clearly stated that situation that happened is the secondary above statement.
Revision petition is allowed. Consequently, the judgment of conviction passed by the so-and-so, dated so-and-so, in CC number so-and-so, and the consequent sentence punishing the offense, petitioner for the offences punishable under section 279, 337, and 304A of IPC set aside. The petitioner is set at liberty. The petitioner is acquitted of the said offences and is set free. Yeah, I will definitely mention.
What's your pleasure?
Good. I think it from today and tomorrow, from the date of receipt of the order on tomorrow, from today and tomorrow. 8 months from the forward. Yes. Yes, Anuradha arrest MD. Come. What is the compensation?
They agreed to pay 5 lakhs.
So whatever it is, we have to. ಯಾವ್ದು ಕಳಿಸ್ತೀರ ಯಾವ್ದು ಆಯ್ತು ಅಟ್ಲೀಸ್ಟ್ ಏನಾದ್ರು ಒಂದು VC ಮುಖಾಂತರ ಆದ್ರೂ ಹಾಜರು ಮಾಡಿ VC who is the other injured is also expired. You can write it. But did he die due to the accident? He did not. So why should he be compensated? He's already got the compensation in MVC.
Not married.
What about the LRs of the deceased? Indira. One son and two daughters. ಹೇಳಿ ನೋಡಿದ್ರ ಅವ್ರು ಹೇಳಿ ನೋಡಿದ್ರ ರವೀಂದ್ರಾಗ ಇವ್ರಿಗೆ ಏನ್ ಸಂಬಂಧ ಅವ್ರು ಕೇಳಿ ನೋಡಿ ಅವರೇ are they willing to pay take some money and close the case ಏನಂತ ಹೇಳ್ತಾರೆ ಅಲ್ಲ are they willing to condone this ನೀವು ಒಪ್ಕೊಳ್ಳಕ್ಕೆ ತಯಾರಿದ್ರೆ ಸ್ವಲ್ಪ ಪರಿಹಾರ ಕೊಟ್ಟು ಇಸ್ಕೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಕ್ಕೆ ತಯಾರಿದ್ದೀರಾ ಎಸ್ ಮೇಡಮ್ ವಾಟ್ ಅಬೌಟ್ ದಟ್ ಅದರ್ ಲೇಡಿ ಅವ್ರಿಗೆ
As far as these people are concerned, they are the in-laws of the deceased, please, Your Lordship. And the other lady is a very old lady, I believe, the information is given by them. Your Lordship may.
ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ 5 ಲಕ್ಷ ಕೊಡಿ ಅವ್ರಿಗೆ 2 ಲಕ್ಷ ಕೊಡಿ 7 lakhs 5 plus 2
We will convince her.
when will you let us know
We will convince them, please.
ಏನಂತ
7 ಲಕ್ಷ ಕೊಡ್ಲೇಬೇಕು.
details LR of that lady that person was injured get the details so that they can make out a demand favoring them ಯಾವ ಕಳಿಸ್ತೀರ ಅವ್ರನ್ನ ಕೇಳಿ ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಎಷ್ಟು ವಯಸ್ಸಾಗಿದೆ ಅವ್ರಿಗೆ ಓಡಾಡಕ್ಕಾಗಲ್ಲ ಅವ್ರ ಕೈಲಿ ಕರ್ಕೊಂಬರಕ್ಕಾಗತ್ತ ನೀವು ಕರ್ಕೊಂಬನ್ನಿ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಂದ್ರೆ ನಿಮಗ್ ದುಡ್ಡು ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ಗೂ ಇಲ್ಲ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಂದ್ರೆ ಮಾತ್ರ ನಿಮ್ ಅವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರಿಗೂ ದುಡ್ಡು ಸಿಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಂದ್ರೆ ಮಾತ್ರ ನಿಮ್ಗೆ ದುಡ್ಡು 31st ಕರ್ಕೊಂಬಂದು just on 31st 7 lakhs madam please
If they give us the information, we can.
ಅದೇ ಅವರೇ let him get details
Government advocate.
ನಂಬರ್ ಇಸ್ಕೊಂಡು ಅವ್ರು ಕೊಡಿ ಅವ್ರು ಮಾತಾಡ್ತಾರೆ
ನಮ್ಗೆ ಒಂದೇ ಸತಿ ಡಿಡಿ ತಗೊಂಡ್ಬರ್ಬೇಕು ಆದ್ರೆ ತಗೊಂಡ್ಬರ್ತಾರೆ.
let that lady come please take that man's number ಅವ್ರ ಹೆಸರು ತಗೊಳ್ಳಿ ಒಂದು 5 ಲಕ್ಷ ಡಿಡಿ ತಗೊಳ್ಳಿ ಆ ಲೇಡಿ ಹೆಸರಿಗೆ ಡಿಡಿ ತಂದ್ಬಿಡಿ ಮುಂದಿನ ತಾರೀಕು so if they come you can close ಎಲ್ಲ ಶೇಖರ್ ಕುಮಾರ್ offense ಏನು yes there is no representation for the petition The order sheet discloses that the petitioner has consistently remained absent. It discloses that the petitioner is not interested to pursue this revision petition. This is a petition is dismissed for non-purpose. Yes, Gupta. Yes, Mr. Gupta. Now, if you do not want to press anything against the respondent number 1, and if you want to only pursue against respondent number 2, you did not obtain sanction. So therefore, how is the case maintained?
Immediate by present citation of Honorable Supreme Court of High Court.
Please read. Please read.
Now this is has to be inquiry to be held whether he has been.
Please read, sir.
Yes, Your Lord. This petition was submitted by the division bank to the Chief Justice for Fabricated, bigger bench. I will read.
The last kindly submitted to read. In case, here, Tata, and versus state government of the city of the county. The state number and of over 9. One thing, the divergence in the statement that the indemnity requirement for proving the offense.
Where are reading page number? Yes.
Okay. And I will do the statement again. Question. Not the research. Differential definition of probability or guilt. 47. 7. 20. 30. 4. Use the very constitution. So I request Lordship to engage in the 65, the last one. Is what emerges from the approach is solid.
Yes.
Proof of demand and acceptance of illegal gratification to the service assignment and
Yes.
in order to bring home, I oh, now that this fact, the issue can be proved. But
No, I'm not on that. I'm not on that. Accused number 2 was a government servant.
One 197 and this one, Your Honor, that is full 6 have been discussed.
You read wherever, whatever you want to
It's
read.
70. It says pages, Your Lordship, 71. If I start reading this, I need a whole day.
Sir, you read it for yourself, point out what is relevant.
For the cases which have been conflicted by the Supreme Court itself, the discussions have been taken for almost all the cases. The final
Please point out the relevant portion in the judgment. Please point out the relevant portion in the judgment.
To save time, Your Lordship, I may come tomorrow or day after tomorrow.
Please do one thing, you come.
I will go through all that marked property. I have not marked it for that, Your Lordship.
Take your time, I've been giving short dates so that I thought I can accommodate you.
Yes, Your
This
Lordship.
is the fourth date I am giving you. So please, Town Counsel for the petitioner seeks time to answer the question whether the complaint against the accused number 2 was maintainable without paying appropriate sanction as provided under law. List on. Good February, I will put 13th February. Take your time. Come fully prepared. Please argue. Don't keep on taking time. I thought you will answer the question quickly, but you're not coming. You are not answering it, despite giving 4 dates of adjournment. Yes, next.
Your Lordship, I have not been stationed on that day.
27th February. 27th. Yes, Prasad. 2013, it has to be taken up today. Will be taken up today. Which day? Please pick a date of your choice. Second February. With the request of the senior counsel. Third February. Request of the respondent this time, 3rd February as a last chance. Sixth February. Yes, madam. Madam, I waited for you till evening. You did not even come to the court. Should have come to the court, isn't it? Correct. You asked your colleague, but after we heard matter, CGP also argued. You did not even turn up. No, you should come to the court. I was there up to 5:45 yesterday. Yes. I was sitting up to 5:45.
have there are 18 charge sheet witnesses involved. Out of the 18 charge sheet witnesses, prosecution have examined 7 witnesses.
Who are they?
PW1, PW7. Plus PW1 has turned hostile. He is one Gurumurthy. PW2, he has, our contention is that he is a planted witness. How he is a planted witness, I substantiate. PW3 is the relative of the deceased. PW4 is also a relative, he is a Mahazar witness. Who is PW3, PW4, PW5 are all, have turned hostile. PW6 and 7 are the IO and another PSI. In this case, the Mahazar Milot, which he also disputes, has mentioned that the vehicle is Mahazar may kindly be taken. ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದ ಪಂಚನಾಮೆ.
Yes. Yes, madam.
That almost towards the end.
PW1 has turned hostile.
PW1, 3, 4, 5 have turned hostile.
1, 3.
1, 3, 4, and 5.
Who's PW2?
PW2 is he says he is the eyewitness. Plus, he supports the case of the prosecution.
Yes.
Plus, in comparison with the sketch, the witness of PW2 in comparison with the sketch. Plus, I substantiate that he is a planted witness, and this accident has not occurred due to the negligence or rash driving of the petitioner here.
Yes.
Plus, the sketch shows that there is on the right hand side of the sketch, there is a line of shop.
Right hand side?
Right hand side of the sketch, there are 4 shops mentioned in the this one. Plus, Vijaya Cafe Works. This
Coffee
is
Works.
Coffee Works. This is where the prosecution says the accident has occurred. Plus, there is a wine shop next to the coffee shop. Plus, the PW2, he says, ನಾನು ಕಾಫಿ ಕುಡಿ ತೆಗೆದುಕೊಂಡು ಹೋಗಲು ಬಂದಿದ್ದೇನೆ. ಕಾಫಿ ವರ್ಕ್ಸ್ ಫೋಟೋ ಸ್ಟುಡಿಯೋ ಇತ್ತು. ಕಾಫಿ ವರ್ಕ್ಸ್ ಪಕ್ಕದಲ್ಲಿ there is a studio. ವಿದ್ಯಾರ್ಥಿ ಮೇಲೆ ಇರುತ್ತದೆ. ಕಾಫಿ ವರ್ಕ್ಸ್ ನ ಹತ್ತಿರ ವೈನ್ ಶಾಪ್ ಇರುವುದು ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ. ಕಾಫಿ ವಿಜಯ ಕಾಫಿ ವರ್ಕ್ಸ್ ನ ಪಕ್ಕ ವೈನ್ ಶಾಪ್ ಇರುತ್ತದೆ ಅಂದರೆ ನೋಡಿ. This is what he says. Plus, we have asked the further Milots. ರತ್ನಮ್ಮ ಸತ್ಯವನ್ನು ಕೊಟ್ಟಿದ್ದು ಆಕೆ ಪೆಟ್ಟು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ ಇಲ್ಲ. He denies it. And he further says, ಸದರಿ ಜಾಗದಲ್ಲಿ 9-9 ಜನಸಂದಣಿ ಸರಿ. ಸದರಿ ರಸ್ತೆಯು ತುಂಬಾ ಚಿಕ್ಕದಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. The accident described by the prosecution is that the Maruti Omni vehicle driven ಅತಿ ವೇಗವಾಗಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಮಾರುತಿ ಓಮ್ನಿ ವ್ಯಾನ್ ಅನ್ನು ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿ ಡಿಕ್ಕಿ ಹೊಡೆದ ಪರಿಣಾಮ ಎಡಕಾಲಿಗೆ ತೀವ್ರ ತರಹದ ಪೆಟ್ಟಾಗಿ ರಕ್ತ ಗಾಯವಾಗಿರುತ್ತದೆ. This is the injury described by them, and the PW1 says that the road is very small and it is a crowded road. Therefore, in the crowded road, obviously it could not have been driven in speed agi ajagarukate through rash and negligent. And he says
you will not be driving the vehicle rash and negligently. Question is whether you exercise due diligence.
Negligence, yes,
Due diligence.
Yes, I'll come to that point. Therefore, the witness of PW2
itself shows that he was not present on the spot and he does not know about the incident. And moreover, he says that it is a crowded space. Further, my lords, in respect of motor vehicles, they have not examined the motor vehicle inspector, Parivikshana Adhikari, Vahana Parivikshana Adhikari, which is fatal to the case because the report of the IMV, which is placed before the trial court, lords, motor vehicles accident report. It mentions the date and time when it was examined, the vehicle number. Says there is no visible damage to the vehicle during my inspection. Therefore, my lords, the Omni vehicle ಅಂತಂದ್ರೆ ಮುಂದೆ ಅದಕ್ಕೆ ಹೆಚ್ಚಿಗೆ ಸ್ಪೇಸ್ ಏನಿರಲ್ಲ. In case if the vehicle had traveled from the car road over coffee katte, then obviously there would have been some damage to the vehicle also. That benefit of doubt will have to be given to the petitioner here with respect to the accident.
Yes. PW2 would ಬೇರೆ support ಮಾಡಿದ್ದಾರೆ.
PW2, that is what is our contention. He is a planted witness who has spoken about these things, and he has clearly said that he does not know what shop is situated very next to the coffee workshop. And it is our contention that
When was the statement recorded?
this
161.
statement has been a 161 statement, my lords, on 12/8, my lords. 12/8. 12/8/2010.
Planted witness.
On 12/8, it has been recorded, and he
Who says a planted witness?
because, my lords, in respect of the prosecution case, he clearly does not know what is where is the accident has taken place, what are the shops. And that further statement that it is a crowded area and the vehicle could not have caused accident. In case crowded area is there, it could not have been that only the deceased was injured. If we had at all come.
Can you share this? Can you be arguing this?
Yes, sir.
Because there's only one lady who was injured. If it's a crowded place, many must have been injured. Can you argue that?
That is exactly the case of the petitioner is that he did not come in high speed and he did not.
Speed ಬೇಕಾಗಿಲ್ಲ. Speed ಬೇಕಾಗಿಲ್ಲ. Negligence ಇದೆಯಾ?
Negligence really not the case. But in the sketch also it can be seen, my lord, that the vehicle is on the tar road, my lord. The other witnesses have also said that the vehicle was in the tar road and not cross the footpath to hit the coffee katte. The other witnesses also, my lord, they have said the same, that vehicle was in the tar road, and further, my lord, the statement of the deceased also, it is stated by the very relative, that is PWC, that the statement of the witness is that she fell down and got injured. PW1 states that Gadi bandu hoddu, she fell down. The other
Who states that?
the statement of deceased also. ಕೆಳಗೆ ಬಿದ್ದು ಪೆಟ್ಟಾಗಿರುತ್ತದೆ, not the statement of.
E4 is her statement. Statement of the deceased.
Yes.
Exhibit? Please read that. When was that recorded? 11/8. When did she die?
Early.
11/8. When did she die?
She died on 14/8/2010.
Please read. ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸ
ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. ದಿನಾಂಕ 11 ಸೆಪ್ಟೆಂಬರ್. ಸುಮಾರು 8:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಗರದ ಶಕ್ತಿ ಬೀದಿಯಲ್ಲಿರುವ ವಿಜಯ ಕಾಫಿ ವರ್ಕ್ಸ್
ಜಯಂತಿ ಕಾಫಿ ವರ್ಕ್. ಜಯಂತಿ ಕಾಫಿ ವರ್ಕ್, ನಾಟ್ ವಿಜಯ. ಜಯಂತಿ ಕಾಫಿ ವರ್ಕ್ಸ್ ಅಂಗಡಿಯ ಮೆಟ್ಟಲ ಮೇಲೆ ಕುಳಿತು
ಕಾಫಿ
ಒಂದು ಮಾರುತಿ ವ್ಯಾನ್ ಅದರ ಚಾಲಕ ಅತಿ ವೇಗ ಹಾಗೂ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ನನಗೆ ಡಿಕ್ಕಿ ಹೊಡಿಸಿದ್ದು. ನಾನು ಕೆಳಗೆ ಬಿದ್ದು ನನಗೆ ಎಡಕಾಲಿಗೆ ಪೆಟ್ಟಾಗಿ ರಕ್ತಗಾಯವಾಗಿರುತ್ತೆ. ತಕ್ಷಣ ಅದೇ ವಾಹನ ಚಾಲಕರು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬಂದು ಜಿಲ್ಲಾ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ತಂದು ಸೇರಿಸಿ ಇದಾಗಿರುತ್ತೆ. T4 ನನ್ನನ್ನು ಎತ್ತಿ ಉಪಚರಿಸಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದವರು ಗುರುಮೂರ್ತಿ ಹಾಗೂ ಮುಕುಂದ. ಮುಕುಂದ ಇಸ್ ಆಲ್ಸೋ ದೇರ್. ಅವರು ಹೇಳಿದರು ಮಾರುತಿ ವ್ಯಾನ್ ನಂಬರ್ 42 ಎಂದು, ಅದರ ಚಾಲಕನ ಹೆಸರು ಕುಮಾರ ಎಂದು ತಿಳಿಯಿತು. ಚಾಲಕನ ಮೇಲೆ ಕಾನೂನು. ಎಸ್.
This is relative, that is PWP. She says that ನನಗೆ ಯಾವುದೇ ಹೇಳಿಕೆ ಆಕೆ ಮಾತನಾಡು ಇರಲಿಲ್ಲ. PWP, the last 3 lines.
Yes. This was a statement recorded in the police hospital.
Yes, but the relative who was with her at the time, she has said that no such son was, she was not in the state of giving statement. Further, my lords, the Mahazar also said that ಮಾರುತಿ ಗಾಡಿಗೆ ಯಾವುದೇ ಜಖಂ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಒಂದು ವೆಹಿಕಲ್ ಇದ್ದು, there is no ಜಖಂ to the vehicle.
There is a wound certificate.
Wound certificate, you know, says that wound certificate and there is only postmortem report. We have postmortem report in which they say the cause of death was due to
Lacerated wound,
and
crushed injury present on the left leg near ankle with fracture of both bones. Rigor mortis present. How old was she?
So 69 years. And cause of death is shown as septicemia.
And hemorrhage.
Hemorrhage.
Shock and hemorrhage.
And relying upon this decision to show that there was no negligence and What's the sequence? The relevant parameter notes that 17 minutes. First petition. In the case of criminal appeal number 10,027. In order to constitute above mentioned offence, the prosecution has to prove rash and negligent driving of the temple by the accused so as to engage in criminal life or consideration the evidence. We see that they have stated temple, but they have not stated that it is the rash and negligent. In fact, in the cross-examination, it is that the temple would have collided with the baggage. Apart from the above, then there is boy coming from opposite crossover. Further, minutes at page para number 22, they have cited the Supreme Court decision and said that merely because vehicle was being driven in high speed does not speak of either negligence or rashness by itself. The prosecution has to bring material on record to establish rashness or negligence. Such evidence is lacking in this case. There is no evidence regarding the distance. So it is not established by prosecution, but the accused was not allowed to be on the road at the time of the accident. Definitely, the vehicle of the by the petitioner was on the far road itself. They had not crossed over to the path and dashed the bench of the coffee shop. It is clearly shown in the.
But I will disputed the sketch, madam. I will disputed the sketch. Give it 3 times.
It is not disputed.
Let us see the cross examination of the IA. What have you mentioned? IOS PW 7. What the NL?
PW 7 is 3.
Let us see what you suggested to PW 7.
Are considered Samakshima
Navakanika.
Investigation connected part.
PW 8 to Sorry, PW 8 goes.
There is clearly no damage to the vehicle.
Not necessary, madam. We cannot reconstruct the spot of the accident or the way in which the accident occurred. That will depend upon the materials placed before the court.
Yes.
Correct. Now, if I will deny the sketch prepared by PW 8. I will said that this sketch does not represent the actual state of affairs at the spot, or there is something else that the PW 8 has not taken note of.
ಸ್ಥಳಮಹಜರನ್ನು ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮಹಜರನ್ನು ಹಾಗೂ ಭಾಷೆಯನ್ನು ಆಣೆಯಲ್ಲಿ ಬರೆದಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆಯಲ್ಲಿ ಠಾಣೆಯಲ್ಲೇ ಬರೆದಿದ್ದೇನೆ. ನಾನು ಹೇಳಿಕೆಯನ್ನು ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ.
So therefore, you are not denying the sketch. You are not denying the sketch. Looking at the sketch, how do you justify coming on to the right lane, going on to the footpath, and dashing against this lady who was sitting on the steps? She might be drunk, no dispute. We will assume that she is drunk. Does it justify you to wander into the footpath and dash against him? Does it justify is the question? And you must have said something like some vehicle came suddenly from the left side. I couldn't control my vehicle. You should show that it's an accident, that there is no negligence in that. That is not at all your defense. You do not say that, okay, some boy came suddenly from the left side. Instead of hitting the boy, I turned to the right, but this lady was sitting there, I couldn't control it. That is not your defense. That is not your defense. And you do not even set out that in the 313 statement also. Do not mention anything in your 313 statement. Not let in any defense evidence. So the material placed on record by the prosecution establishes some case that corroborates the accident and the negligence.
But the death of the case is not occurred.
Hemorrhage.
Because,
Maybe because of her old age, the wounds have not healed. So therefore, she has died due to septicemia. ಅಷ್ಟೇನಾ ಬರ್ಕೊಳ್ತೀನಿ.
the decision means, the decision got. Yeah, was 1979 to 1848. Yes. The relevant para is 34.
Yes, year 2000.
Yeah, 1970.
Yes.
The relevant para is para number 34.
24.
34.
Yes, please read.
So thus evidence that the accident happened due to error of judgment and not negligence or want of driving skill on part of the accused. An error of judgment of the kind such as the one in the incident case, which comes to light only from action, but could not be foreseen by the accused that fragmented movement before accident. This is not a sure index of negligence, particularly when taking and executing that decision. Accused was acting with confidence and belief that would be adopted for everyone safety.
So therefore, is this your defense? This is not your defense. And you please look at the facts of this case. It was in evidence that the metal road, there was hardly 12 feet in width, and there were very deep ditches on both sides of the road. Since the child was at that critical moment initially in the road, more towards the left side, the accused might have thought that if he tried to run past the child from the extreme left, there was every risk of the bus rolling down into the ditch. He therefore thought the best way to avoid the ditch and to avoid the collision and forestall the move of the child would be to steer the vehicle to the extreme right side. Is that your defense?
Because set out by the petitioner herein is that he has that the victim was drunk and she had injured herself.
How do you prove that difference?
It's the non-examination of the motor vehicles inspector is fatal to the case.
Petitioner challenge
And,
the judgment of conviction dated so the CC number so past is so convicting him for the offences punishable in section 138, sorry, section 279. Two 304A of IPC and the consequent sentence to pay fine of rupees 1,000 for the offence punishable section 279 and simple imprisonment for a period of 6 months with fine of ₹1,000. The petitioner has also challenged the correctness of the judgment passed by the appellate court in criminal appeal number 215 of 2012. Stop. The case of the prosecution was that on 11/8/2010 at about 8:30 p.m. the accused, who was driving a Maruti Omni van bearing registration number KA03MA9099, drove it in a rash and negligent manner and dashed against the deceased, who was sitting on the steps in front of Jayanti Coffee Works. Stop. The deceased was shifted to the hospital where her statement was recorded. However, she died on 15th,
14
on 14/8/2010. Stop. Based on the complaint lodged by PW1, proceedings, the jurisdictional police registered crime number 75 of 2010 for the offences punishable under section 279, 337 IPC. And after her death, they included section 304 of 304A of IPC. I took up investigation. To stop. PW, it was the investigating officer who recorded the statements of the witnesses and also conducted an inquest and recorded a spot master. To stop. He seized the vehicle, which was subjected to inspection by the motor vehicle inspector, who reported that the accident was not due to any mechanical defects. To stop. Based on the above, the IO submitted a charge sheet for the offences punishable under section 279 and 304A of IPC. The trial court took cognizance and registered CC number 1213 of 2010 and issued summons to the accused. The accused appeared and was enlarged and was released on bail. A copy of the charge sheet was published to him and his view was recorded. The accused pleaded not guilty and claimed to be tried. The prosecution examined PW1 to PW8 and marked exhibits P1 to P10. The statement of the accused under section 313 of CRPC was recorded and he denied the evidence, the incriminating evidence against him. However, he did not need any evidence in defense. Next, based on the oral and documentary evidence, the trial court noticed that PW1, who was the complainant and an eyewitness, turned hostile, while PW3 was the brother-in-law of the deceased, who was a brother-in-law, Ajaya, was the brother-in-law of the deceased, who is a hearsay witness. PW4 and PW5 were the major witnesses who supported the prosecution.
They are not very
Turned hostile. Full stop. PW4 who turned hostile. Full stop. PW7, PW8 was the investigating officer who recorded the statements and also drew a spot sketch, which was marked as Exhibit P9. Full stop. The investigation was taken out by PW7, who submitted a charge sheet to the court. So the trial court, after considering the evidence of PW2 and the spot sketch at Exhibit P9, held that the accused accused drove the vehicle in question rash and negligently and caused the accident. And caused the accidental death of the deceased. Full stop. The trial court therefore found the accused guilty of the offences punishable under section 279 and 304A, and consequently convicted him for the said offences and sentenced him accordingly. So, being agreed by the said judgment of conviction, the accused filed criminal appeal 215 of 2012. The appellate court secured the records of the trial court, heard the learned counsel for the accused as well as the learned public prosecutor for the state and framed points for consideration. The appellate court reconsidered the evidence on record and in terms of its judgment dated 5/8/2013 dismissed the appeal. Confirmed the judgment of conviction passed by the trial court. Being agreed with the said judgment of conviction and the order of sentence passed by the trial court, which was upheld by the appellate court, the accused is in revision. The learned counsel for the petitioner submits that except PW2, all the other except PW2, the complainant slash PW1 who had lodged the complaint, had turned hostile. He submitted that the seizure of the vehicle in question was not proved as PW4 turned hostile, while the PW4 and 5 turned hostile. He submitted that PW2 was a planted witness in as much as he did not identify the shops found in Exhibit P9. Full stop. He therefore submitted that the evidence placed before the trial court was not sufficient to justify the judgment of conviction for the offences punishable under section 79 and 304A of IPC. Full stop. The CGP, on the other hand, contended that Exhibit P4 was the statement of the deceased, which was recorded who recorded it? It was recorded by P4 was PW6 in question. It was recorded by PW6. PW6. However, the credibility of PW6 was not shaken. Full stop. PW2 was a witness. PW2 was cited by the deceased in her statement in Exhibit P4. Full stop. Therefore, the contention of the learned counsel for the petitioner that he was a planted witness is unsustainable. Full stop. He further contended that PW2 was a witness who saw the accident occurring in front of his eyes, and his evidence corroborated the sketch at Exhibit P9. Full stop. He therefore contended that the evidence, therefore contended that though PW1 and PW4 and 5 turned hostile, but yet, there was sufficient evidence on record which corroborated the accident as well as the negligence on the part of the accused in causing the accident. Stop. Therefore, contended that the trial court as well as the appellate court had rightly held that the prosecution had established case beyond any doubt. Learned counsel for the petitioner further contended that the motor vehicle inspector was not examined before the court, and the report at Exhibit P8 did not disclose any damage to the vehicle in question. Stop. She therefore contended that the accident was not caused by the vehicle in question. Stop. The vehicle in question, but the deceased suffered injuries due to a fall as she was drunk. I have considered submissions made by the learned counsel for the petitioner, learned counsel for the petitioner / accused, as well as the learned HCG. Next paragraph. PW2 was an eyewitness who categorically deposed before trial court that he saw the accident occur in front of his eyes. To stop. He deposed that the offending vehicle crossed over to the right side lane and moved on to the path and dashed against the deceased who was sitting on a step. Sitting on a step, putting Jayanti Coffee Works. The step in front of Jayanti Coffee Works. To stop. He also identified the accused as the person who was driving the vehicle and who caused the accident. Stop. This evidence of PW2 clearly corroborates with the sketch at Exhibit P9. Full stop. The petitioner accused did not challenge the correctness of Exhibit P9 when P9 in the course of cross-examination of PW7 and PW8. Full stop. The post-mortem of the deceased discloses that the accident was due to septicemia and shock and hemorrhage. And as per the external appearance, it was found that the deceased had suffered a lacerated wound above the pubis and a crushed injury for the left leg near the ankle with fracture of both bones. We'll stop. The accused did not explain any circumstance which resulted, any unavoidable circumstance which resulted in the accident, or the reason for he to swerve his vehicle to the right lane and move on to the footpath and dash against the deceased. Full stop. In that way of the full stop. A producer of Exhibit P9 indicates that the road was only 16 feet wide road was only 16 feet wide. And as suggested to PW, 8, comma, there was PW 8, comma, the road was crowded, and therefore, comma, it was incumbent upon the accused to have exercised due care and caution while traveling on a crowded street. Full stop. It only is the sketch at exhibit P9 makes it apparent that the accused was not diligent while driving the vehicle and was not in a position to bring it under control due to bring it under control. However, as per exhibit P8, which was the IMV report submitted by the motor vehicle inspector, the accident did not occur due to any mechanical defects, and therefore, comma, the only irresistible conclusion would be that the accused was not diligent in driving the vehicle in question, and he was rash and negligent, and therefore thereby he caused the accidental death of the deceased. The trial court as well as the appellate court have appreciated the evidence on record and have rightly held that the prosecution had proved the guilt beyond any doubt. Full stop. There's no. This court did not see any procedural irregularity in the trial or in the trial of the case or by the appellate court in the disposal of the appeal, warranting interference by this court in division. Hence, this division petition lacks. Yes, Mr. Muralidhar. Mr. G. Muralidhar. Rathore. The Pravartan arrest.
Accused is convicted for the offense punishable under 323 and 506. A trial court sentenced the middle kind of court confirmed the sentence report. My lords, the case of the prosecution is that, my lords, there was a photo station arranged for a purpose of issue for a ration card, my lords. There, my lords, PW1, 2 and 4 was deployed for the purpose of maintaining the crowd, my lords. My lords, first, thereafter, my lords, the PW1 identifies accused number 1. As per them, he was the accused in another crime, my lords. So, when the PW1 went to arrest the accused number 1, so he obstructed and the case is that he obstructed them and abused them and hit them, my lords. My lords, thereafter, FIR came to be registered, my lords. There were totally 20 witnesses, my lords, and all independent witnesses has not supported the case of the prosecution, my lords. My lords, even the after this site incident, my lords, the PW1 was not taken to the hospital nearby, my lords. He was taken to the hospital 20 kilometers away from the place of incident. And my lords, even the PW17 statement, that is doctor's statement, it says that those injuries occurs if the person falls on a certain objects. Yes. And the PW1, as per the case where they were trying to arrest me, I was acquitted in that crime number also, my lords. My lords, the trial court, based on the official witness and independent witness, my lords, convicted me, my lords. And there was no independent witness, my lords.
Who is the complainant?
PW1 is the complainant, my lords. The police constable was deployed for this security purpose. And when PW1 tried to stop, this is their case, my lord. When they tried to stop me, I abused them and slapped them. And no witness, the independent witness, come forward to confirm the same, my lord. That they have not supported their case. I just those in we were the actual the official who were deployed to taking photographs, my lords. The village accountant and other officials, even in their statement, they have not supported the case of prosecution, my lords, based on the statement of and out of 6 statements, my lords, 3 were their colleagues. On their statement, I was convicted.
Yes. Yes, sir.
Their legal statements W17 statement.
W17.
Doctor's examination methods. ನಾನು ಕಳೆದ 6 ವರ್ಷಗಳಿಂದ ನುಣಿಕೆ ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರದಲ್ಲಿ ವೈದ್ಯರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೇನೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ದಿನಾಂಕ 21/11/2009 ಮಧ್ಯಾಹ್ನ 2:30 ಸಮಯದಲ್ಲಿ ಶಾಸವನ್ನು ಇವರನ್ನು ತಪಾಸಣೆ ಮಾಡಿದಾಗ ಅವರ ದೇಹದ ಮೇಲೆ ಈ ಕೆಳಕಂಡ ಗಾಯಗಳು ಕಂಡುಬರುತ್ತದೆ. ಎಡಮುಂಗೈ ಕೆಳಭಾಗದಲ್ಲಿ 2x3 ಸೆಮಿ ಅಳತೆಯ ಉದ್ದ ಗಾಯ, ಬಲ ಮುಂಗೈ ಮಧ್ಯಭಾಗದಲ್ಲಿ 0.5x3 ಅಳತೆಯ ತರಚು ಗಾಯ, ಬಲಗಡೆ ಮುಟ್ಟಿದಾಗ ನೋವಿನಿಂದ ಕೂಡಿತ್ತು. ಆರೋಪಿ ಪರ ವಕೀಲ ಸ್ವಯಂಸೋ ಇವರಿಂದ ಪಾಟಿ ಸವಾಲು. 2 ಯಾವುದೇ ವ್ಯಕ್ತಿ ವಾಹನದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದ ತರ್ಕು ಸ್ಥಳ ಮೇಲೆ ಬಿದ್ದಂತಹ ಸಂದರ್ಭದಲ್ಲಿ 1 ಮತ್ತು 2ನೇ ಗಾಯ ಆಗುತ್ತದೆ ಎಂದರೆ ಆಗಬಹುದು. 3ನೇ ಗಾಯ ಯಾವುದೇ ವ್ಯಕ್ತಿ ನಡೆದಾಡುತ್ತಿದ್ದಾಗ ಆಯತಪ್ಪಿ ಕೆಳಗೆ ಬಿದ್ದರೆ ಆಗುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 3ನೇ ಗಾಯ ಯಾವುದಾದರೂ ಒಂದು ವಸ್ತು ಅದರ ಮೇಲೆ ಬಿದ್ದರೆ ಗಾಯವಾಗುತ್ತದೆ ಎಂದರೆ ಆಗಬಹುದೆಂದರೆ ಸರಿ. My lords, as per their case, and they've demonstrated in such a way that I've hit this PW1 when he tried to arrest me. And as per the cross-examination of PW17, it says that it can happen even the person falls on some object. My lords, my whole case is that, my lords, now only for some personal vendetta, my lords, they have incriminated me in this offense, my lords, and there is no strong witness and no independent witness to support their case, my lords.
Yes. This is trial court judgment. What? Where is the discretion?
Page dot. Page 14, my lord.
Yes.
Para 24, they discuss.
Usually, para 27 and 28.
Para 24, my lord. PW 17, the doctor has reports that he had examined the complainant at about 2:30 p.m. and found the simple injuries on him and then issued the wound certificate as per Exhibit P11. The defense have contended the injuries mentioned in the wound certificate can be happen if a person falls on a hard object, but his admission of a doctor will not make the whole wound certificate unbelievable as the accused have got injuries to the internal
Please come
part.
to page number 10. Page number 9, last sentence. In the instant case, the alleged offence is obstructing the complainant in performing his public duty, and it is clearly supported by the other witnesses. Since the evidence of the complaint is enough against the accused, we cannot expect such strict proof from the prosecution. But on a perusal of the evidence of the complaint, it is clear that his evidence is come to a conclusion. On the alleged date of an incident, the accused had committed the alleged offence as narrated by the prosecution. Contention taken by the defense in the cross-examination cannot be taken into consideration to the innocence. Yeah, Nitra Baradre.
But 28 of these in the
On
on perusal of the above evidence.
Para 20 of
28, page number 21 of my paper book, judgment, in the page 16. On perusal of above evidences, it is clear that the independent eyewitness and panchas have not supported the case of prosecution. And at the same time, the official witness and investigation officer have supported the case of prosecution. Under these circumstances, the evidence of the supportive prosecution witness cannot be thrown out for the reason that they will be termed as an interested witness, and moreover, the defense is not successful anything in their paper. The defense are contending that the evidence of prosecution witness cannot be taken against the accused as they will be termed as interested witness, but learned APP had contended that the interested witness cannot be equated with the related witness. The evidence of the prosecution witness are enough to hold the guilt of the accused beyond reasonable doubt, as strict proof is not expected. So the prosecution is able to prove the guilt of the accused. The paramount consideration of the court is to ensure the miscarriage of justice.
what about the appellate court? What does it do?
I've taken the content that is the page, and page 35.
Yes. P23 is put together 2 months. Three months, huh? 506, huh? 2 months. Fine impose ಮಾಡಬಹುದಲ್ಲ 53 ನಲ್ಲಿ ಇದು maximum fine. You will impose fine, there are no eyewitnesses. Yeah. Could be that, they went to arrest him. Maybe in the melee, they could have suffered some injury. You do not know. ಹಿಡಿಯಕ್ಕೆ ಹೋದಾಗೆಲ್ಲ ಒದ್ದಾಡ್ದಾಗ ಏನೋ ಆಗ್ತಿರ್ಬೋದು.
Witness turned
Word 2 and 4.
Their colleagues who were deployed, my lords, along with PW1.
Impose some fine. 253 are there. Even that is can be the fine of the sentence of fine can be imposed even in 353. Is a rowdy sheet ಅಂತೆಲ್ಲ ಹೇಳ್ತಾರೆ. Therefore, we will impose a fine. Substantial fine will impose. We will declare total. Mr. Acharya. Acharya. ನೆನ್ನೆ ಇತ್ತಲ್ವ ಇದು? ಇಲ್ಲ ಇತ್ತ? ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ. Mr. B.S. Prasad. Mr. Prasad B.S. Huh? Password. Station Suresh. Password. ಏನು offense ಏನ್ರಿ? ಇದು ಸಿಯರ್ ಅಲ್ಲ. Password. Score.
Friend for the petition in this case, my lord. Conviction for 457, 380, my lord. In this case, my lord, the petitioner is not known where he is and he is absconding, my lord, for the past 2 years. The whereabout is not known to me because I tried through all the source. And also for the file, my lord, during my shifting of my office, the file was misplaced, and I have told my colleague to apply for the entire document now. Conviction for 457 and 380, my lord.
Yes.
There,
What is the
my,
error?
in the judgment portion, my lord, it is mentioned the offence has taken place on 1/4/2011, and there is a date of complaint on 1/2/4/2011. There is inordinate delay of 1 day. The allegation, some temple items, my lord, was stolen. And they were seized after 8 months, my lord. When two constable, that is PW 4 and 6, they were while on patrolling duty on 7/12/2011, they noticed that this petitioner was near the Om jewelries of that Pandpura. There, then on the inquiry, they found that the stolen items were with them. That is the allegation, my lord. After 8 months of the incident, their marks are also drawn. This is the conviction based, my lord. No eyewitness to the incident, and complainant is the priest of the temple. He says that the stolen
Recovery was made from you.
my lord.
The recovery was made from you.
They say that it is from me, but
However, they proved the recovery.
It is not prosecution has not examined or produced any document to say that the property belongs to temple. Where the property was purchased and what is the bill, other details are not there. They cannot say that the property which sealed it not belongs to temple at all.
Yes. What does PW1 say about the properties?
PW says that he is a priest and he said that it was on the night it was stolen. A complaint is lodged on the next day.
Has he identified this MOs 1 to 4? Has he identified it?
Yeah, he identifies, my lord. PW1 identifies, but he says that watchman to the temple. But on the particular date, he was not in that temple. He was sleeping in another temple. That is his contention.
Who was the watchman accused?
Accused is not the watchman.
Who is the watchman?
Watchman was appointed there. He was not sleeping on the particular day in the temple. He was sleeping in some another temple. That is their contention. Recovery is after 8 months.
Yes.
That PW4 and 6, their constable, during their patrolling duty, they noticed that this petitioner was near the jewelry shop.
Yes.
Only on the basis of that, my lord, he was convicted.
Yes.
No other eyewitness to the incident.
What does PW1 say?
PW1, that is documents is not with me, my lord. Files are misplaced. Only on the judgment basis, this time laying. PW1 in page number PW29, million. During evidence, PW1 complaint state on 1/4/2011. During night hours, somebody has stolen donation box, 3 thalis and 2 beads from the temple. Later on, next day, he filed complaint. Police conducted a spot measure on 7/12/2011. Once again, police called him to police station, shown the 2 thalis and 2 beads of the temple, and accused stated that stated that accused himself is the culprit in his cross-examination. Also, he stated details about the incident. Though he's not to the incident, only after 8 months, because incident on 1/4/2011, the major was drawn on 7/12/2011.
Yes.
After 8 months, they suspected and inquired. Why is really a theft? You would have pledged the ornaments within a few days or the next day. This is after 8 months. There is no evidence to show that the property belongs to temple. Only on the say of PW1 is the priest, he says that ನಂದೇ ದೇವಸ್ಥಾನದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರ್ವೈಸ್ ಇದು ದೇವಸ್ಥಾನದಲ್ಲಿ ಇತ್ತು, ಇದು ಇಂಥ ತಾರೀಕು ತಗೊಂಡಿದ್ವಿ, ಇಂಥ ಡೊನೇಷನ್ ನಮಗೆ ಕೊಟ್ಟಿದ್ರು ಅಂತನೋ ಅಥವಾ ದೇವಸ್ಥಾನ ಮಾಡಿಸಿದೀವಿ ಅಂತನೋ, there is no evidence.
Identified it, Mr. Identified it. PW1 has identified the ornaments.
Right. PW1 is never definitely he'll identify. ಯಾವ್ದೋ ಒಂದು ದೇವಸ್ಥಾನಕ್ಕೆ ಬಂದಿರೋದು, because in natural course we have seen in the police station, ಇವನ್ ಥೆಫ್ಟ್ ಕೇಸಸ್ ಅಲ್ಲಿ ನಿಮ್ದು ಒಡವೆ ಸಿಗಲ್ಲಮ್ಮ, ಈ ಸಿಕ್ಕಿರೋದು ಯಾವ್ದೋ ಒಂದು ಒಡವೆ ಇದೆ ನಂದೇ ಅಂತ ಹೇಳಿ ತಗೊಳಮ್ಮ. That is all going on during day-to-day affairs.
Yes. Please read the evidence of PW 5 and 6.
5 and 6 also, my lord. It is page number 30. Para 16. PW 5 the ASI who registered the FIR and conducted the spot measure. PW my lord is the another constable who accompanied the PW 5 during the patrolling. Also that on 7/12/2011, when he was on patrolling duty, 2 persons were there near home jewelries, golden jewelries. Golden and bears were there with those 2 persons. When they did give proper answer, they took both of them to the police station. Later on, they both have admitted about committing the theft of different places. And PSI recovered the articles which were in possession of those 2 persons. In cross-examination, also PW 5 and 6 have stated the detail regarding recovery of the article from the accused person. It is very doubtful. 8 months, they say that in a different 2 places, because temple, according to the PW1, temple has stolen on 1/4. These people, after the 8 months, they say that ಇದನ್ನ 2 ಕಡೆಯಿಂದ ನಾವು ಕಳ್ತನ ಮಾಡಿದೀವಿ ಅಂತ, ಇಬ್ರು ಆರೋಪಿಗಳಿದ್ರು ಅಂತ. ಬಟ್ ಇದರಲ್ಲಿ 8 months ಆದ್ಮೇಲೆ ಇವರು ರಿಕವರಿ ಮಾಡೋದಕ್ಕೆ ಅಥವಾ ರಿಕವರಿ ಮಾಡಿರೋದೇ ನಮ್ದೇ ಟೆಂಪಲ್ದು ಅನ್ನೋದಕ್ಕೆ PW1 ಹೇಳೋದ್ ಬಿಟ್ರೆ there is no material at all.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸಮಯ ಲೈವ್ ವಿಟ್ನೆಸ್ ಇಲ್ಲ. ಓನ್ಲಿ ಆಫ್ಟರ್ ಲ್ಯಾಪ್ಸ್ ಆಫ್ 8 months they have concocted ಅಷ್ಟೇ.
Yes, good. The petitioner has challenged the judgment of conviction dated so fast number 22 of 2012, convicting for the offence punishable section 457 and 380 of IPC, and the consequent sentence to pay fine of ₹2,000. The consequent sentence to undergo simple imprisonment for 2 years and pay fine of ₹1,000 for the offence punishable section 457, and to undergo simple imprisonment for 2 years and to pay fine of ₹1,000 for the offence punishable under section 380 of IPC. Next paragraph. The case of the prosecution was that on 2/4/2011 at 10:45 AM, complaint was lodged stating that someone had stolen the donation box of Omkareshwara temple on 1/4/2011 and had also stolen 3 golden thalis and 2 golden beads from the statue of goddess Parvati in the temple situated at Puttayana Koppalu of Pandavpura village, Pandavpura Taluk. Penakopul of Pandavpura Taluk. Full stop. Based on the complaint, the police registered crime number 49 of 2011. Sorry, 204 of 2011. 204 of 2011 for the offences punishable under section 457 and 380 of IPC. Full stop. PW 6. PW 4. On 7/12/2011. PW 4 was deputed to investigate the offence.
There was patrolling duty, my lord, not investigation. On
He
patrol,
was on patrolling duty. Found the accused persons. Found the accused attempting to dispose of the
even they are not told anything about dispose of, my lord. Only near he was there. He was
I-
there. That jewelry, Holmes jewelry. You are
You have
near.
the evidence. You have the evidence with you.
No, my lord. I don't have.
Then I have the evidence with me.
Please, my lord.
I'm
Please,
reading it from the evidence.
please, my lord.
Yes. That found that two persons were attempting to dispose of the thali and golden beads at Home Jewelers on Srirangapatna Srirangapatna
Market Street.
Market Street, KTB, Market Street. And when inquired, they attempted to flee from the spot. To stop. PW4 apprehended them, and after investigation, it was found that the said persons had stolen the jewels from several temples. Full stop. PW1 was the complainant was summoned, and he identified the jewels as the ones that were stolen from the temple. Full stop. Based on this, the investigating officer arrested the accused and conducted further investigation and recorded the evidence of witnesses and filed a charge sheet for the offences punishable in section 457 and 380 of IPC. Stop. The accused pleaded not guilty and claimed to be tried. The prosecution examined PW1 and PW7 and marked P12, P6 and MOs 1 to 4. Stop. The statement of the accused was recorded in P13 of CRPC to deny the incriminating evidence against him. So, however, he did not read any evidence in the case. Based on the oral and documentary evidence, the trial court held that the prosecution had proved the guilt of the accused beyond any doubt. It held that the recovery of the gold articles from the recovery of the gold articles on the say of the accused was proved as proved as per the statement of PW3. and PW2. Full stop. PW4 was the police constable on patrolling duty, also supported the case of the prosecution. PW6 was another constable who accompanied PW4, who also supported the case of the prosecution. Full stop. PW1 identified the gold articles that were seized from the custody of, that was recovered on the say of the accused. Full stop. The trial court therefore held that the prosecution had proved the commission of the offences by the accused beyond doubt, and hence convicted him for the offences considered in the section 380 and 447, and sentenced him to undergo simple imprisonment for 2 years, along with fine of ₹1,000 for each of the offences mentioned above. Being assumed by the said judgment of conviction, the accused filed an appeal for the appellate court in Criminal Appeal 55 of 2013. The appellate court secured the records of the trial court, heard the learned counsel for the accused as well as the learned public prosecutor. It also framed points for consideration and reconsidered the evidence on record, and in terms of its judgment, dated so and so, dismissed the appeal. So being reviewed by the same, the present judicial petition is filed. Next paragraph. The learned counsel for the petitioner submits that the prosecution had failed to establish that the jewels recovered was the jewels owned by the temple. Full stop. He submitted that this was a crucial fact that had to be established with the prosecution to drive home the offence under section 380 and 457 of IPC. He also submitted that the prosecution's claimed to have recovered these jewels after nearly 10 months,
8 months.
nearly at the date of the commission of the alleged offence, and therefore the case presented by the prosecution was doubtful. Stop. He submitted that both the trial court and the appellate court failed to consider this relevant fact, but relied heavily on the evidence of PW 4 to 6 as well as PW1 to return a finding that the prosecution had proved the guilt of the accused beyond doubt. Stop. The learned HCGP, on the other hand, submitted that the recovery of the gold ornaments from the accused is proved by PWs 4 to 6, and the same were identified by PW1, and the said gold ornaments were released to the usual custody of PW1, and therefore, the prosecution had indeed proved the guilt of the accused beyond doubt. To stop. I consider submission made by the learned counsel for the petitioner accused as well as the learned HCGP. The offence was allegedly committed on 11/4/2011.
Yes, madam.
Was registered on 2/4/2011 at 2 p.m. by PW1. Full stop. PW1 deposed that during December 2011, deposed that on 7th December 2011, the investigating officer had secured the accused along with the gold ornaments gold ornaments, which were identified by PW1. Full stop. PW1 identified the persons who were brought before him on the said day, when the accused persons were examined before the court. Though there were no eyewitnesses to the incident, the fact that the gold ornaments were recovered at the say of the accused, and that PW's 4 to 6 have testified that these gold ornaments were recovered from the recovered at the instance of the accused. And since those gold ornaments were identified by PW1, the prosecution had indeed proved the complicity of the accused in the offense beyond any doubt. The trial court and the appellate court had assessed the evidence before it, and after considering the same, have rightly returned a finding that the accused was guilty of the offense punishable under sections 380 and 457 of IPC. There is no error apparent on the face of the record warranting interference by this court. As this revision lacks merit in the.
Please, ma'am.
Remember, 44. Yeah, sir, person in next day, any day. 2016, madam.
This is the learned counsel for the petitioner is found grateful. Is that an FD or? Yashaswini. For how many years this before? 5 years. Yashaswini is Rekha. Rekha there. You Rekha, huh? ಮಗಳಿಗೋಸ್ಕರ ಕೊಡಿಸಿರೋದು ಇದು ಅವಳಿಗೆ ಉಪಯೋಗ ಆಗಲಿ ಒಳ್ಳೇದಾಗಲಿ. Number 76. Learn counsel for the respondent seeks time. Respondent number 1 seeks time. List down on date.
41, madam.
Still number?
Comparing with the petitioner. 41.
Yes,
I have received information that the respondent has passed 41.
Learn counsel for the petitioner. Substance of the respondent have expired and seeks time to bring the legal representatives. It's on 6th road. ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿ 138 ಎಲ್ಲ ಎಂತದ್ದು 2014 ಅಲ್ಲ ದಯವಿಟ್ಟು ಇಟ್ಕೋಬೋದು.
Yeah, madam.
Page number
80 of the compilation of.
80.
80.
80 is some Andhra
I'm
Pradesh.
sorry, I'm sorry. 53. 53 minutes. Para 13, my lords of 53. Now, my lords, it's the case of the complainant that this is a part payment. Our loan is given as the checks that have been put is in pursuance of a part payment. Para 13, my lords, it says, it must be noted that when a part payment is made after the issuance of a post-dated check, the legally enforceable debt at the time of encashment is less than the sum represented in the check. A part payment or a fully payment made may have been made between the date when the debt has occurred to the date when the check is sought to be encashed. Thus, it is crucial that we refer to the law laid down by this court in issuance of post-dated checks and checks issued for the purpose of security. Then, my lords, a number of judgments are cited, my lords. Then, my lords, may kindly see para 16.
Yes.
Based on the above analysis of precedent, the following principles emerge. Where the borrower agrees to repay the loan within a specified timeline and issues a check for security, but defaults in repaying the loan within the timeline, the check matures for representation. When the check is sought to be encashed by the debtor, it is dishonored. Section 138 of the Act will be attracted. However, the cardinal rule when the check is issued for security is that between the date on which the check is drawn to the date on which the check matures, the loan could be repaid through any other mode. It is only where the loan is not repaid through any other mode within the due date that the check would mature for presentation. If the loan has been discharged before the due date, or if there is an altered situation, then the check shall not be represented for encashment.
Yes.
My lords, then, my lords may kindly see para 20.
This is Mr. Karnataka. You are not there. What is the use of hearing?
My lords, they have not been appearing from the beginning, my lords. My lords may see the order.
Appears to the court. One counsel for the response is absent. At the last chance, more. Yes. More. Passion party. Last one reach out of the line here, but again offensive. 304A. This Mr. 32 password, 31 password. This Basavaraju. Balu Mahendra. Password. Password. Rao. Star Vidyanathan. Is offensive.
130.
I am for the respondent, Your Honor.
You are ready?
Yes.
Yes, please go on.
Petition. Both the courts below have communicated the accused. This is reason by the accused.
What is the error? What is the error?
For errors of fact and just telling the last part. First, the last is turn to the notice. Exhibit B10. For a moment, we are like to kindly. B10. The notice dated 9/8/2004.
Notice of demand.
Notice of demand in respect of checks of 50,000 each alleged to have been issued to the complainant.
With P10.
P10 is a notice. Now, the very first paragraph, my client instructs me to state that you borrowed a sum of 15 lakhs for your urgent and emergency purpose by agreeing to repay the same at the earliest. my client instructs me to state that you assured my client that you will return back the loan amount without delay and delay as agreed, and I don't understand what it is. Without delay and delay, and as agreed and promised. All these things are contradictions by in itself. First of all, it does not say when the date of the alleged loan is not shown. It's very material. Number
Yes.
one. Secondly, my lord, what is the purpose? According to this notice is urgent and emergent. In the complaint, there is a deviation. It says for business purpose. Now, there is again a contradiction there. The third one, my lord, is hand loan. The third is the hand loan. Now, there is no written contract of loan anywhere pleaded or stated. In which date that alleged loan was taken, for what purpose it was taken. The contradiction is in the complaint. I'll come to that later. Now, these three checks, which is alleged to have been issued by specific contention from trial court, even under 313 statement, and also my defense is that I never issued this check to this person. It was not even a blank check that is issued by me. It was a check which was lost. I have given a complaint to the bank also. Where a number of checks were lost. Is a series of numbers was given. I have produced that letter given to the bank also later.
How many checks were lost?
Several checks, somewhere 7 or 8 checks. Exhibit.
D6.
Exhibit D3 to D6. Stop payment letters are available. Now, with this background, I would like to take a lordship to the complaint, directly to the complaint. Now, the complaint. Para 2 of the complaint assumes importance. I submit that the accused has borrowed a sum of 15 lakhs as hand loan for his business purpose, and also to clear the urgent debts, agreeing to repay the same at the earliest on demand. A very vague statement is made, without no specifications at all. Because there was no such hand loan at all.
Yes.
The check which has been somehow which has fallen to the hands has been misused to an unimaginable astronomical extent of 15 lakhs. Now we also 15. Then it's a reiteration of the is what they have said. And then he has launched the criminal process.
Yes.
Now I take your lordship through, because there is a, so far as the examination chief is concerned, is only a reiteration of the complaint, where they have marked as many as 10 documents, exhibit 3-1 to 310.
What is the date of your letter to the bank? 26/6/2004. Yes, what is there to show that this letter was submitted to the bank?
Exhibit D6.
What is there to show that this was submitted to the bank?
Checks were lost.
Sir, what is there to show that this letter, exhibit D6, D5 or D6 was submitted to the bank? You prepared the letter on 26, sent it by RPD on 30th, and by certificate of posting on 29th.
I am one of the customers of your exchange bank having a current account expenses also. The details of misplaced due checks are in the below. Several out of this, the checks in question are 378330, 338331, 378332 among other checks. These are totally branch checks. I request you to stop the payment. Now, this was given to the bank. Now, I will take your lordship through the cross-examination portion of the complainant. Because several admissions made by the complainant itself goes to show that this is purely a false case hosted by them. Party Saval. Yes, page 4 of the cross-examination. Party Saval ಆರೋಪಿ ಪರ ವಕೀಲರಿಂದ ವೀನಸ್ ಮೆಟೀರಿಯಲ್ ವರ್ಕ್ಸ್ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಉದ್ಯಮ ಇದೆ. ಇದುವರೆಗೂ ಯಾವುದೇ ದಾಖಲಾತಿಯನ್ನು ಇದರ ಬಗ್ಗೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಆದಾಯ ಕರ ಅಸೆಸಿ ಎನ್ನುವುದು ನಿಜ. ನನ್ನ ಆದಾಯ ಕರ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ನನ್ನ ಸಾಲದ ಹಣವನ್ನು ತೋರಿಸಿಲ್ಲ. ಇದುವರೆಗೂ ನನ್ನ ಬಳಿ 2004ರಲ್ಲಿ ಅಷ್ಟೊಂದು ಹಣ ಇತ್ತು ಎಂದು ತೋರಿಸುವ ದಾಖಲಾತಿಯನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ. 15 ಲಕ್ಷ. ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಾಗಲಿ ಫಿರ್ಯಾದಿಯಲ್ಲಾಗಲಿ ಬೇಡಿಕೆ ಪತ್ರದಲ್ಲಾಗಲಿ ಯಾವ ನಿರ್ದಿಷ್ಟವಾದ ದಿನದಂದು ಮಹಿಳಾ ಆರೋಪಿಗೆ ಹಣ ಕೊಟ್ಟೆ ಎಂದು ತೋರಿಸಿಲ್ಲ. 15 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣವನ್ನು ನಗದಾಗಿ ಕೊಟ್ಟೆ ಅಥವಾ ಚೆಕ್ ಮೂಲಕ ಕೊಟ್ಟೆ ಎಂಬುದನ್ನು ತೋರಿಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. 20,000ಕ್ಕಿಂತ ಹೆಚ್ಚು ಮೇಲ್ಪಟ್ಟ ಹಣವನ್ನು ಚೆಕ್ ಮೂಲಕ ಕೊಡಬೇಕು ನಿಯಮವಿದೆ ಎಂದರೆ ನಿಜ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಚೆಕ್ ಹೊರತಾಗಿ ಬೇರೆ ಯಾವ ದಾಖಲಾತಿಯನ್ನು ಆರೋಪಿಯಿಂದ ಪಡೆಯಲಿಲ್ಲ. ಹಣ ಕೊಟ್ಟ ದಿನದಂದೇ ಆರೋಪಿ ಚೆಕ್ ಕೊಟ್ಟಳು ಎಂದು ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಬರೆಸಿರುವುದಿಲ್ಲ.
ನನ್ನ ಸಹೋದರ ಹರಿ. ನನ್ನ ಸಹೋದರ ಹರಿ ಇದ್ದಾರೆ. ಅವರು ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದಾಗ ತಂದ ಕೆಲವು ಚೆಕ್ಕುಗಳನ್ನು ಅವನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಸುಳ್ಳು ಪ್ರಕರಣವನ್ನು ದಾಖಲು ಮಾಡಿದ್ದೇನೆ ಸುಳ್ಳು. ಆರೋಪಿಗೂ ಹರಿಗೆ ಏನ್ ಸಂಬಂಧ ಇದೆ? ಹರಿ, ಹೂ ಇಸ್ ದಿಸ್ ಹರಿ? ನೀವೇ ಕ್ವಶನ್ ಕೇಳಿದ್ರಿ. ಯು ಪುಟ್ ಎ ಕ್ವಶನ್ ಟು ಹಿಮ್. ನನ್ನ ಸಹೋದರ ಹರಿ ಇದ್ದಾರೆ. ಅವರು ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದಾಗ ತಂದ ಕೆಲವು ಚೆಕ್ಕುಗಳನ್ನು ಅವನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು
employee of this accused. ಏನಾಗಿದೆ ಈ ಚೆಕ್ಸ್ ಆಲ್ಸೋ ಕಮ್ ಇನ್ ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್. ಇಟ್ ವಾಸ್ ಕೆಪ್ಟ್ ಫಾರ್ ಪೇಮೆಂಟ್ ಸಮ್ ಎಲೆಕ್ಟ್ರಿಕ್ ಬಿಲ್ಸ್. ಅದು ಸೀಲ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರು. ಅದನ್ನ somehow it has fallen to his hands of this complaint and he has received ಒಂದು ಮುಂದೆ ಹೇಳಿದ್ರು. ನಾನು ಅಲ್ಲಿ ಹೋಗ್ಲಿಲ್ಲ. ನಾನು ಇನ್ನ ಹಣ ಕೊಟ್ಟ ದಿನದೇ ಜೂನ್ ತಿಂಗಳಲ್ಲಿ ಆರೋಪಿಗೆ ಹಣ ಹಿಂತಿರುಗಿಸುವಂತ ಹೇಳಿದೆ ಅನ್ನೋದು ಕೂಡ ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಬರೆಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಚೆಕ್ಗಳನ್ನು ಕೊಟ್ಟ ದಿನಾಂಕಗಳನ್ನು ಕೂಡ ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಕಾಣಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅಂದ್ರೆ ಇದು ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಬ್ಲಾಂಕ್ ಚೆಕ್ಸ್ ಥ್ರೋ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಸಿಗ್ನೇಚರ್. ಚೆಕ್ಗಳನ್ನು ಬ್ಯಾಂಕ್ಗೆ ಹಾಜರುಪಡಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಆರೋಪಿಗೆ ಬರವಣಿಗೆಯಲ್ಲಿ ತಿಳಿಸುವ ಅವಶ್ಯಕತೆ ಇರಲಿಲ್ಲ. ಚೆಕ್ಗಳಲ್ಲಿ ವಿವರಗಳನ್ನು ಆರೋಪಿ ಬರೆದಿಲ್ಲ ಎಂಬುದು ಸುಳ್ಳು. ಚೆಕ್ಗಳಿನ ರುಜುಗಳು ಹಾಗೂ ಆರೋಪಿಯ ರುಜುಗಳಲ್ಲಿ ಇಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಚೆಕ್ಗಳಲ್ಲಿರುವ ರುಜುಗಳಿಗೂ ಹಾಗೂ ಆಪಾದನೆಯಲ್ಲಿರುವ ರುಜುವಿಗೂ ಅಧಿಕಾರ ಪತ್ರದಲ್ಲಿರುವ ರುಜುವಿಗೂ ವ್ಯತ್ಯಾಸವಿದೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಚೆಕ್ಗಳಿನ ರುಜುಗಳನ್ನು ಹಾಗೂ ಅವುಗಳಿಂದ ವಿಧಿವಟ್ಟು ನಾನೇ ಫೋರ್ಜರಿ ಮಾಡಿದ್ದೇನೆ ಸುಳ್ಳು. ನನ್ನ ಸಹೋದರ ಹರಿ ಅದ್ರ ಬಗ್ಗೆ ಏನಾಗಿದೆ ಕಟ್ಟಾಗಿ ಹೋಗಿದೆ. ಪ್ರಿಂಟ್ ಕಟ್ಟಾಗಿ ಹೋಗಿ ನಾನು ಓದ್ತೀನಿ ಆಗಿದೆ. ಸ್ಟ್ಯಾಂಡ್ ಬೈ. ನಾನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಸುಳ್ಳು ಪ್ರಕರಣವನ್ನು ಮಾಡಿದ್ದೇನೆ ಅಂದರೆ ಸುಳ್ಳು. ನಾನು ಯಾವುದೇ ಸಾಲವನ್ನು ಆರೋಪಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಹಾಗೂ ಆರೋಪಿ ಚೆಕ್ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸುಳ್ಳು. ಈಗ ಫಾರ್ ಎ ಮೊಮೆಂಟ್ the lordship may kindly see the checks.
The problem is, if you say that the checks were given for the payment of some electricity bill, kept paid to Bescamo, Discamo, and you would have had the bill. The bill will definitely be with you. Correct? So therefore you must have filled up the check. How do you establish that a blank check falls into the hands of a person named Hari, and that man goes to the complainant and misses it?
The very admission of the complainant that it were all blank checks ಅಂತ ನಾನು ಯಾವುದು ಪೂರ್ವದಲ್ಲಿ ಬರೆದಿಲ್ಲ ಅಂತ. ಈಗ ಅದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಇಸ್ ಫೋರ್ಜ್ಡ್ ಅಂತ ತೋರಿಸೋದಕ್ಕೆ for a moment your lordship turn to the.
Have you taken any steps?
Yes, I will come to that. Twice I have taken steps. And unfortunately, the court recalled the warrant before the report was done. I'll come to that. It's a important issue. Now, for a moment, you will have to see the checks. That is exhibit P2, P3, P4. For a moment, the signatures on that check.
Yes, please.
2, 3, 4 ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಸಿಗ್ನೇಚರ್ ಮತ್ತು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಎಲ್ಲ ನನ್ನ ಸಿಗ್ನೇಚರ್ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ಒಂದಕ್ಕೊಂದು ಸಂಬಂಧನೇ ಇಲ್ಲ.
Totally it is different. It is forged. Now, in the course of evidence, first an application was made. So to send these checks for FSL to the government level. I will take your lordship to the order sheet when it was sent. The first application was filed under 45 and the orders were passed. An order was passed on 28/10/2006. It is in the order sheet itself. Orders on application filed under 45 for sending it to FSL Madiwala. 28/10/2006. Is there a look at that will make that this is good. Number of other signatures are available. Actually, the accused was asked to sign in the open court so that could be sent for comparison. She has also signed in the open court. That report was returned back.
This has to be compared with the signatures in the bank. Bank compare model. Not with whatever that you have produced now. Bank signature is it has to be compared with that. Not what is produced before the court.
Apart from that, there are other documents.
You do not know what is the signature found in the bank. So therefore, that bank document will have to be summoned.
That is one aspect. I agree with your lordship, that particular aspect. The undisputed documents containing the signatures were also produced before this trial court, exhibit D1, D2, D3. Sales tax certificate produced by other that is the.
No, but this signature and your admitted signature also do not match. Please come to the signature found in this exhibit D1 and compare it with the signature found in exhibit D5. They do not match. Your signature, sir, exhibit D1 to D, compare exhibit D1 to D5, compare both the documents. Your signature do not match. D1 to D5, D1 and D5 compare multi. And you compare the signature found on the wakalat. They do not match.
D1, D2,
D1 and D5.
D5.
And the wakalat filed by your client. Will match agutte.
ಇದು ರಿಸ್ಪಾನ್ಸ್ ಕಳಿಸಿರೋ ನಮ್ಮ ಯಾವ್ದು ಎಂಪ್ಲಾಯಿ ಅಂತ ಸ್ಟೇಟ್ಮೆಂಟ್
ಏನು
ಮ್ಯಾನೇಜರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅವರಿಗೆ ಕಳಿಸಿದ್ದಾರೆ.
It is not manager, sir. It is sent by Lily Joseph. Signed by Lily Joseph. D5. Sorry, D6. D6 is sent by Lily Joseph.
Oh, D6.
Compare ಮಾಡಿ ಅದಕ್ಕೂ ಅದಕ್ಕೂ. Don't need an expert to say that both the signatures do not match. Now compare it with the wakalat. Sorry, ಕೊಡ್ರಿ ಅವ್ರು. Of Lily Joseph. I put a green flag. Match ಆಗುತ್ತಾ? ಸ್ವಲ್ಪ ಏನು sir? Does it match with exhibit D1? Be frank, sir. There is a world of a difference between the signature found at exhibit D1 and the wakalat. See the strokes, see the way it is bent. It is bent on the left, towards the left. Whereas the signature in exhibit D1 is almost round shaped. L nodi, Y nodi, J nodi, O nodi. Everything is in a round shape in exhibit D1. How can you say it is comparable? So therefore, we have to compare it with the bank statement, whatever records are found in the bank. It has to be compared with that.
Summoned the bank manager.
What are the documents to show that you summoned or you try to get this compared? Illegal.
Application.
What happened to that application? Yes, application.
Such a computer is not, there is an order on 28/10/2006.
2010.
28/10/2006 is the first order. The order sheet is outside.
Yes, please read.
Order on application filed and modified Indian evidence. It is an application not filed by the accused is where the record is checked with the state director, Sir Mariwala, Bangalore City for examination report. The body of the application is alleged that she has borrowed 15 lakhs, hand loan for business purpose, also to clear the urgent debts. It is alleged further that she had issued 3 checks in dispute for 5 lakh each of SBI Procedural branch funds. At no point of time she approached him for 15 lakhs for improvement of business. She has not at all issued for discharge of the liability for any amount in favor of the complainant. Entire contents of the check, including the signatures, are not her signature and not written by her. One Harish is a relative and is taken away without her knowledge, cheated and claimed wrongfully filled up the entire content of check and filed for house purpose. The signature on checks and signature on the deed warrant are different. Not ample rebuttal evidence to disprove this complaint, and hence entirely repetitive. The other side has filed objection stating that the checks in dispute were issued towards discharge of legally repairable debt. If documents on the checks are written by the accused, there is any defect. The bank officials would find out that type of variation. Harish is a brother's complaint and he has not taken any check from the house of the accused. These are mastermind of the billing signature in many types. Hence, inter alia the application is so and so. The check amount is huge amount of 15 lakhs and that is and law. The accused is a woman. While recording the plea, she has denied the accusation. Even in the cross-examination of Pillar 1, there is a specific defense. The signatures and content are not written by the accused. PW1 pleads ignorance as to the difference or variation in the signatures found in check. Till 1, key form of the accused. It is stated that Harish is a brother. He suggested that Harish, brother of the complainant, used to visit the house of the accused, stolen the checks and filed the false complaint. Seen the signature on check P2 and plea form dated 20/4/2006. While recording the plea, she has taken a specific plan that checks have not been issued by her. With this backdrop to have scientific evidence to ensure fair and even handed case and justice, the point is answered in affirmative. The application is allowed directly to deposit necessary legal charges for scientific investigation and a report has sought for immediately. Record the documents of this order was passed. We had deposited the amount as required in law for that report. Now that report came back without any result. A reminder was also sent. Various endorsements on the order sheets on various days show that that particular report was not received. Then they returned that report without any result. Then we made one more application for a private lab, that is 2 lakhs. Another application was filed.
But those checks mean the signature found on the check are definitely not comparable with the signatures found on exhibit D5. They definitely cannot be compared because it is visible to the naked eye. Why should it be compared? But it should be compared with the admitted signature found in the bank. What is the signature found in the bank?
That's on our part that we should have summoned the bank manager along with the personal signature for comparison, which would have cleared the entire issue. So far as checked, signatures on the issue, that's correct. So that aspect should have been appropriate for the accused to summon the bank manager and produce the acknowledgement.
Who appears for the respondent?
I am from the,
Are you willing to settle the dispute?
yes, Your Honor, we are willing to rest to the dispute, Your Honor.
No, but what is there to show that you have paid this kind of money, 15 lakhs, in the year 2004?
No, he was running a huge business, Your Honor, during the time that
Correct, but with no documents, you paid this 15 lakhs to a stranger, just like that.
no, she is known to the in compliant very much, Your Honor. They were
What is the
definitely-
evidence?
no, they were going and meeting regularly some classes, yoga classes, something. Just in that they were being acquainted with that.
Extracted that in the cross-examination.
Sorry, Your Honor.
Have you extracted that in the cross-examination that they
No,
know
Your
each
Honor,
other?
first of all, when I see what their contention is, they have lost the check. But basically what has happened is when we give a notice, nowhere in the notice, reply notice, he has not at all replied. Stating that your check has been lost, how did you acquire? They are not even one word has been raised in the reply. They should have given a reply notice to Your Honor.
Yes,
They are not raised any reply notice in that issue.
right, but what is there to show that there was a debt due? No doubt there is a presumption in your favor. There is a presumption in your favor. Has she admitted the signature found on the check?
No, Your Honor, because she has only given the check. That she has not, see, what she has told in the, this one was when Hari and his brother has stolen the check.
I
That is
asked you
what-
a question.
Ah.
Has she admitted her signature on the checks? Yes or no?
Yes, Your Honor.
Please read.
It is false that the signature found in exhibit belongs to me. It is false that I have categorically denied in the cross examination. Beyond this statement, I will deny.
Earlier, I was having the factory, the name and style of living. At that time, I have obtained a small license.
Yes, Mister. He has disputed her signature. He disputed the signature on the check. What is there to show that that is her signature?
It's false, Your Honor.
Please come to paragraph number 3. Sorry, paragraph number 4.
I submit that the check in question of the honorable signature contained in the check does not belong to me, and also the date mentioned in the check is not of mine, and it is totally different by handwriting.
Yes.
So by plain statement stating that she has made a statement that she has check is not disputed because she has not taken the specimen signature of the bank, and then compare the signature. Just plainly says she is filing an affidavit stating that I have not given, it is not my signature, it doesn't hold any good, Your Honor. Bank does not say that this check is not yours, but saying is not, they are not come across with the statement stating that your check is mismatching. That is not dispute on that, Your Honor. The bank has to.
The signatures will be compared only when there is sufficient balance. Signatures will be compared only when there is sufficient balance in the account. There is no balance, the bank will not go to verify whether the checks are.
But irrespective of this one, even suppose if check is not tallying with the signature, they will say, first they will say that signature is mismatching, they may also write no, Your Honor.
They will not go for signature verification. If there is no sufficient balance. What do you want to do?
No, we will settle the matter, like that. No, because it is logged, it has been logging in 19 years, Your Honor. 2004, the check has been.
Correct. If you ask for a bloated claim, this is what happens. You ask for something which is genuine. Maybe they'll settle. If you ask,
No,
go for a.
no,
bloated
no,
claim,
Your Honor. See, the complainant is not a such a this one. It is only a factual the thing they are right. So instead of rating a 5 lakhs, they would have taken 15 lakhs also, Your Honor. It is not that, Your Honor. The accused is admitted that the
look at the signatures. It is in a different ink. All the 3 checks are in different ink. And the person who has filled up the check is also in a different ink. Ink differs in all the 3 checks.
because he is having running a company, he might have get it filled by some other clerk or something, Your Honor. It is not-
All assumptions, sir. There is
Ah.
nothing to show that you had that money. Nothing to show
No.
that there was debt. Nothing to show that this check was given towards a debt. There's nothing to prove that these are the signatures of that lady.
No, the complainant is having a huge property and use their worth, they are running a business,
Sir.
running a.
Please, we are in a court of law. So therefore, let us see what is the evidence that you produced. What is the evidence that you have produced? You don't, the presumption under section 139 cannot be drawn in your case because you not proved that the signatures found on the check. That you have not proved. So presumption is not available under 139. So therefore, it is for you to establish that there was a debt. What is that? What have you produced to establish that there is a debt?
Very
Mr.
good.
White.
Sorry, Your Honor.
There is, in your case, presumption under section 139 cannot be drawn. So therefore, you will have to prove that there was a debt. And that the check in question was given towards repayment of the debt. We may have to dismiss this complaint to allow the revision petition.
No, Your Honor, because I paid the money, Your Honor, I paid money.
Better you
and,
sit and settle, Mr. Otherwise, this complaint will have to go. There's nothing.
We are ready to settle the matter, Your Honor. We are ready and ready to settle the matter. Without knowing that, sir, 1 check, what is sir? 3 checks they are given, sir. Is not your.
I have to say that you not issue the reply, not settled at the earliest point in time. Both of you, I think it is, both of you have failed to clearly demonstrate. You had the first opportunity to deny, you did not do. In 313, you are not mentioned.
Also mention money.
Right.
Consistently, I said.
And you look at your conduct, 26/6/2004, you keep the letter ready to the bank. You send it on 30th, after 4 days. 30th consider 4 days. And you say that the complaint's brother is to come to my house, he has picked up the check. And that these checks were meant to fill up, pay the electricity bills. Right. If you pay, if you drawn the checks to pay the electricity bills, obviously you mentioned the supply company, name of the supply company. You would have mentioned the amount payable.
ಚಕ್ಸಿ ಇರುತ್ತೆ 3-4 ಇರುತ್ತೆ ಸೀಲ್ ಹಾಕಿ ಇಟ್ಟಿರ್ತಾರೆ ಬೇಕಾದಾಗ ಅವ್ರು ಕಳಿಸಿ ಮಾಡ್ತಾರೆ ಇಸ್ಕಾನ್ ಅಂತ ಬರೆದಿಟ್ಟಿದೆ ಇವರು ಕೂಡ ಪ್ರಶ್ನೆ ಇರಲಿಲ್ಲ
Better you settle. It looks like there's some transaction. Looks like there's some transaction because you know Hari, who is the brother of the complainant, and brother of the complainant is to come to your house. So it is not as if you people do not know each other. So there is some transaction. You settle it, sit and settle it.
Even the check the distinctive numbers are different, Your Honor. It is not in a serial wise. They are running from 30, it's 30,000, 60,000, 70,000, 4.
Yes. Sir, please go through section 139. Please go through 139. Mr. Vaidyanathan, are you there?
Yeah, yes, Your Honor.
If you are not proved the signatures, then you don't get the presumption. If you don't get the presumption, then you have to prove it.
Presumption under section.
Yes. When do you want it? Really, how? Do please pick a date of your choice. I will not I will not adjourn the case again.
No, I will.
This is rather and decide.
About the citations and prayer honor for a judgment.
Now I look at your conduct also. You will out. With the request of the Land Council for the petition dishonor. At the request of the Land Council for the petition dishonor, also to explore the possibility of settlement. It's made clear that no adjournment will be granted in the legislative hearing. Our court date. 3rd February.
What third?
2nd February.
Second, third, let us.
1st February.
First of.
1st February.
Okay.
Ramesh. Yeah.
Check amount is 2 lakhs.
Password letter. Ramesh. Ramesh. 35. Password. Prasanna DP. Yes. And counsel for the petitioner submits to the response as expired and seeks time to bring the legal error. List on. All right. Huh? If it does not come, I'll dismiss it. I'm telling you seriously. Ashok Kumar. Idambara. Everybody wants an adjournment. ಎಲ್ಲರಿಗೂ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕು. Somebody should argue.
ಫೈಲಿಂಗ್ ಥಿಂಗ್ ಎಲ್ಲ 69 ಏಜ್ ಆಗಿದೆ ಸರ್. ಇದಾರೆ ಇಲ್ಲ ಅನ್ನೋದು ನಮ್ಗೆ ಸ್ವಲ್ಪ ಇದಿದೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ. ಸೊ ನಾನು ಒಂದು ಲೆಟರ್ ಬರ್ತೀವಿ ಒಂದು 3 days.
Not necessary. Please argue.
Friday.
Please argue, Mr. Please argue. ಏನು ಬೇರೆ ಮಾತು ಹೇಳಿ. What is the check amount?
ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಕೂಡ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ.
What is the check amount?
1,20,000.
1,20,000. What is your defense?
ಇದು ಬಂದು ಫೈನಾನ್ಷಿಯಲ್ ಆಗಿ ನಡೆಸಿರೋದು. ಫೈನಾನ್ಷಿಯಲ್ ಆಗಿ ನಡೆಸಿರೋದು. ಇದರಲ್ಲಿ ಯಾವುದೇ ತರ ಅವರು ಇದು ನಡೆಸ್ತಿದೆ ಅನ್ನೋದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೂಡ ಕೊಟ್ಟಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಬಂದು ಅವ್ರ ತಂದೆಯವ್ರು ಹಾಕಿದ್ದಾರೆ ಚನ್ನಬಸಪ್ಪ ಅಂತ. ಸೊ ಎವಿಡೆನ್ಸ್ ಬಂದು ಅವ್ರ ಮಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಷಡಾಕ್ಷರಿ ಅಂದ್ಬಿಟ್ಟು ಎವಿಡೆನ್ಸ್ ಅವ್ರದ್ದು ಹಾಕಿದ್ದಾರೆ.
Yes.
ಅವರು 3% ಬಡ್ಡಿಯಾಗಿ ತಗೊಳ್ತಿದ್ದೆ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ದಾರೆ. ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 8 ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 17 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ 60 ಪೇಜ್ ನಂಬರ್ 60 para 19.
What is the name of the accused? Veerappa. Open. Veerappa 42,161. 37,000. 76. Yes.
Page number 16.
ಇಲ್ಲ ಚೆಕ್ ಅಲ್ಲಿ ಹೋಗಿರೋದು ಪೇಮೆಂಟ್.
ಇವರು ಫೈನಾನ್ಷಿಯಲ್ ಅಲ್ಲಿ ಇದು ಮಾಡಿರೋ ಸೆಕ್ಯೂರಿಟಿಗೋಸ್ಕರ ಚೆಕ್ ಕೊಟ್ಟಿದ್ರು.
ನಿಮಗೂ ಚೆಕ್ ಅಲ್ಲೇ ಬಂದಿದೆ ದುಡ್ಡು, ಈ ಚೆಕ್ ಅಲ್ಲಿ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಚೆಕ್ ಸೆಕ್ಯೂರಿಟಿಗೋಸ್ಕರ, ಸೆಕ್ಯೂರಿಟಿ ಪರ್ಪಸ್.
ಸೆಕ್ಯೂರಿಟಿ ಯಾವ ಸೆಕ್ಯೂರಿಟಿ? ಫಾರ್ ವಾಟ್? ಸೆಕ್ಯೂರಿಟಿ ಇದ್ರೇನು? ಸೆಕ್ಯೂರಿಟಿ ಅಂದ್ರೆ ಏನೋ ತಗೊಂಡಿದ್ರೆ ಅದ್ರ ಭದ್ರತೆ. ಭದ್ರತೆ ಏನ್ ಭದ್ರತೆ?
ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
ಅಮೌಂಟ್ ತಗೊಂಡೋದು ಭದ್ರತೆ. ಅಮೌಂಟ್ ತಗೊಂಡಿರೋದಕ್ಕೆ ಭದ್ರತೆ ಕೊಟ್ಟಿರೋದ? ವಾಪಸ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಅಷ್ಟೇನಾ? The petitioner has challenged the judgment of various counsel, Dr. Counsel, and consequent sentence to pay fine of Mr. Counsel. Petitioner has also challenged the judgment of the appellate court in criminal appeal of Mr. The records disclose that the petitioner, the respondent had advanced the sum of rupees 42, sum of rupees. The record shows that the petitioner had availed a loan of rupees 50,000 on 1/9/2001 from the respondent and a sum of rupees 30,000 on 9/2/2003. 9/2/2002, na? 9/2/2000. He also borrowed a sum of rupees 10,000 on 11/2/2002 and another sum of rupees 30,000 on 21/2/2002. It was claimed that the petitioner had in all borrowed a sum of rupees 1,20,000 from the respondent and had agreed to pay and agreed to repay it with interest at the rate of 3% per annum, 3% per month. The petitioner, respondent claimed that the petitioner was dodging the repayment of the amount, and after great persuasion, he relented and handed over a check for a sum of rupees 1,20,000 on 24/4/2003. However, the said check was dishonored due to insufficient funds, which prompted the petitioner to issue a notice of demand calling upon the petitioner, prompted the respondent, calling upon the petitioner to repay said sum of rupees 1,20,000. The notice was duly served upon the petitioner, who who did not reply to the notice and did not repay the amount. The petitioner therefore launched prosecution. The respondent therefore launched prosecution of the petitioner for the offence punishable section 38 of the own statement of the respondent was recorded in PC number 4 was registered, and process was issued to the petitioner, who appeared and was released on bail. Stop. The petitioner pleaded not guilty and claimed to be tried. The respondent was examined as PW1 and he marked exhibits P1 to P9. The statement of the petitioner was recorded in section 313 of CRPC, who did not set out any defense, but merely denied the incriminating evidence against him. Based on oral and documentary evidence, the trial court held that the petitioner in terms of exhibit P9, the petitioner had availed sum of rupees 42,161.66. Rupees 30,000 on 9/2/2002, the sum of rupees 10,000 on 11/2/2002, and the sum of rupees 30,000 on 21/2/2002, which were evident from the account extract of the respondent. It also noticed from the counterfoils of the checks maintained by the respondent that the balance sum of rupees 50,000 was paid to the petitioner on 9/2/2002. Stop. Since the petitioner did not deny his signatures on the check in question, and since he did not deny that the check was drawn from his account, or the trial court drew the presumption under section 138 of the Negotiable Instruments Act and held that the petitioner was guilty of the offence punishable under section 138 of the Negotiable Instruments Act, and consequently convicted him for the said offence and sentenced him to pay a fine of rupees dash. Being agreed with the same, being agreed with the said judgment of conviction, the petitioner filed criminal appeal numbers also. So the appellate court secured the records of the trial court, heard the counsel for the petitioner as well as the respondent, and framed points for consideration and reconsidered the entire evidence on record, and held that the petitioner had failed to reply to the notice of demand issued by the respondent. It also held that the evidence in the exhibit P9 demonstrated beyond doubt that the respondent had paid a sum of rupees 70,000 to the petitioner through his account. It also held that the petitioner had received a sum of rupees 50,000 from the petitioner, from the respondent. Therefore, held that the respondent had proved the debt payable by the petitioner. It also held that since the petitioner did not dispute his signature on the check and that the checks in question were drawn from his account, the appellate court held that the appellate court drew the presumption of section 138 of the Negotiable Instrument and held that the petitioner did not point out to any defense to rebut the presumption under section 138 of the Negotiable Instrument. Thus dismissed the appeal. Being agreed by the same, the present revision petition is filed. The learned counsel for the petitioner submitted that the check in question was tendered to the respondent to be retained as security for the landlord. Full stop. He submitted that the petitioner had not given any instructions to the respondent to encash it. However, he had done it on his own. Therefore, no offence was made out under section 138 of the Negotiable Instrument. The petitioner, on the other hand, the learned counsel for the respondent submitted that the transaction in question is not disputed as the amounts were paid to the petitioner through account the account, to the account of the respondent. He also submitted that the counterfoils of the check indicate that the sum of rupees 50,000 was paid to the petitioner, and therefore, the petitioner was able to pay sum of rupees 1,20,000, for which he had drawn the check in question. Stop. I consider submission made by the learned counsel for the parties. Next paragraph. As rightly contended by the learned counsel for the respondent, the documents placed on record demonstrate that the petitioner and the respondent, petitioner had raised a loan from the respondent and had drawn the check in question towards repayment of the said amount. The said check having been dishonored for due to insufficient funds, the petitioner had committed an offence punishable under Section 138 of the Negotiable Instruments Act. The trial court had rightly drawn the presumption under Section 139 of the Negotiable Instruments Act and had rightly convicted the petitioner of said offence, and rightly sentenced him to pay fine of rupees 2,20,000. Having regard to the fact that the check in question was drawn on 24/4/2003, the case has lingered on from the year 2003 till the year 2000. The year 2000, trial court allowed this to lingered on till date. Stop. There is no error apparent on the face of the record warranting interference, revision under Section 397 of the Code of Criminal Procedure. Hence, this revision petition lacks merit and interest. Any amount in deposit has been released to the respondent. Check bond. What is it? Case, you know. Who was for the respondent? Manjunath, Srinivas Murthy. Manjunath. Why do you need time? Whom do you represent? In which case, Mr. 40. Yeah, what has happened? What has convicted you? No, what is wrong? When do you want? Yeah, how short? How short? When do you want? This was the learned counsel for the petitioner. On 30th January as the last term. Made clear that no adjournment shall be granted on the next day. That is more real, Ray. More argument matter for the decide mana. Learned counsel for the petitioners. These revision petitions along with criminal revision petition 776 tomorrow. The Kashyap Naik. Yes.
468, 471, 420, that is 34.
468,
421, 420, that is 34.
Yeah.
Concurrent findings, conviction. The case against me not, I am accused number 1. Trial was split up, A2 is supposedly absconding. The entire case revolves around me allegedly using certain demand drafts which were forged.
they were in my favor, obtained by accused number 2. No dispute that they were obtained by accused number 2. No dispute that accused number 2 was an employee of the bank which filed the complaint. The only ground on which I have been convicted is that I would have knowledge of that of the forgery because I did not inquire with the bank when I received that forged document, whether it is forged or not. So I may take your honor through the trial court judgment first. Commences at page 30. It should be.
Page 30.
Page 30 is the, sorry, page 32 onwards is the, it is the allegation of the prosecution that both the accused with dishonest intention with an intention to have wrongful gain opened a bank account in the name of accused number 1 at Syndicate Bank Coromandel branch and on 12/6/2021. Accused number 2 got a DD in favor of accused number 1 for rupees 80 in favor of accused number 1 and produced the same before Syndicate Bank Coromandel branch by fabricating the same for rupees 80,000 and got the amount credited to the account of accused number 1. Similarly, accused number 2 obtained another DD for rupees 150 in favor of accused number 1, presented the same at Syndicate Bank Coromandel branch by fabricating the same for rupees 1,50,000 and attempted to draw the amount to the credit of account number 1, thereby accused committed the offensive function. The charge also reads in the same language around. The entire case is founded on section 34 because it's not a separable charge. They only say you have jointly done this. They do not say anything against me individually. They do not say I have fabricated the document. They do not say you had knowledge of the document being fabricated and therefore tried to credit it. None of that. The entire charge reads as paragraph 2 that you have jointly done all of these three things together. So I just continue reading. Accused number 2 has been absconding and hence the case against accused number 2 has been split up. Now, my assumption at this juncture would be they could not have split up the case like this because their entire case is predicated on 34. Without there being a finding on accused number 2, there could not have been a finding that I have done something jointly with accused number 2 or with common intent. In any case, on the merits of my own case, Your Honor will see that this
What has happened to the charge? Against A2. Correct. What has happened to whether he has been traced or not? Whether he is traced or not?
To my knowledge, they have not made cases as it was. Nothing has moved. A2 is in fact a former employee of the bank. They have not even inquired with the bank whether that person is still working there or not. It shows the level of investigation that they have done before filing this charge sheet. As required in 207, I will not go through that. We'll go straight to page 33, reasons. Point number 1. It is the allegation of the prosecution that both the accused have intentionally, again the same paragraph is called out. To prove the guilt of the accused, prosecution examined in all 6 witnesses. 5 of those witnesses are bank employees. The 6th is the FSL, handwriting expert. All the prosecution witnesses have deposed in consonance with the case of the prosecution. The very specific case of the prosecution that the pay order for rupees 80 obtained by accused number 2 in favor of accused number 1, fabricated for 80,000, the same was presented with Syndicate Bank, with which accused number 1 was having his account, got credited the amount of rupees 80,000. Similarly, demand offer 150 was changed to 1,50,000. Now we have to see whether the aforesaid pay order and the demand drafts were ever fabricated. The said pay order has been marked at Exhibit P7 and same is dated 12/6/2001, while the said demand draft has been marked at Exhibit P3 and the same is dated 21/8/2001. PW1 has deposed in her examination chief that she had prepared pay order for rupees 80 on accused number 2 paying rupees 80 in favor of accused number 1, and she has identified the challan at Exhibit P8. On perusal of the Exhibit P8, it gets clear that accused number 2 had applied for issuance of pay order for rupees 80 in favor of accused number 1 and had paid rupees 80 and commission charges. Evidence of PW1 and the challan at Exhibit P8 shows that the pay order was issued for rupees 80 and not for 80,000. This implies that the pay order has been fabricated for 80,000 as against the issue of the same for 80. On perusal of the challan submitted by accused number 2 for getting the DD issued in favor of the accused number 1, it gets clear that the accused number 2 had applied for issuance of DD for rupees 150 in favor of the accused number 1 and paid 150 in commission charges. Evidence in prosecution witnesses and the said challan would show that the demand draft was issued for 150 and not for 1,50,000. The last line is further. The FSL expert has also opined that the said pay order and demand draft have been fabricated as alleged by the prosecution. The report of the FSL expert confirms the same. The FSL expert only says these documents are fabricated. Instead of 150, you can see that something has been erased and 3 zeros have been added. The FSL expert does not identify who has fabricated it. He does not say A1 did it, A2 did it, or any person has done it. He only says it is fabricated. Friends, continue. Further, the accused number 1 has not at all produced any evidence contrary to the evidence produced by the prosecution in this regard. Under the circumstances, it can very well be presumed that the pay order and the demand draft have been fabricated as alleged by the prosecution as to the amount therein. Now it is the case of the prosecution that the accused number one got credited the altered amount of 80,000 on presentation of the amount of the order and attempted to get credited altered amount of 1,50,000 on presentation of the amount of demand draft. This allegation has not been denied by the accused number one.
Which is our bank?
Our bank is Syndicate Bank. She was working at Syndicate Bank. She got a demand draft done from her own bank.
Where did the accused number one have his account?
At the Syndicate Bank itself.
Same.
Same bank, different branch.
No, A1 had his account where?
At Syndicate Bank, Kormangala branch.
And where was this demand draft drawn from?
JC Road branch. Syndicate Bank, JC Road branch.
So the accused number one must have been in custody of the demand draft.
It was handed to me. My entire case is that A2 has given me the demand draft in repayment of a loan that she owed me. I have produced loan agreement. I have said that is why I have reasonable cause to believe that it was a genuine document.
Go on.
This allegation has not been denied by the accused number one because that is not my case. That is not forged at all. I cannot say whether it is forged or not. Also, my case. Hence, it can very well be concluded that accused number one got credited and altered the amount of 80,000 on presentation of the aforesaid pay order and attempted to get credited altered amount of 1,50,000 on presentation of the demand draft. It is the allegation of the prosecution that accused number one made wrongful gain by getting the altered amount of 80,000 on presentation of the aforesaid pay order and attempted to have a wrongful gain by attempting to get altered amount of 1,50,000. This court has already come to a conclusion that the pay order has been fabricated pursuant to amount and demand draft has been fabricated pursuant to amount against the actual issue amount. This court has also come to a conclusion that accused number one got credited the altered amount of 80,000 on presentation and attempted to get credited altered amount of 1,50,000 on presentation of the demand draft. Hence, it can very well be presumed that the accused number one made wrongful gain by getting the altered amount of 80,000 rupees 1,50,000. Now, my submission is the word presumed is a very dangerous word to use in a judgment. This presumption goes against not only the evidence, but also is clearly not an inference that the court is drawing. It is not that the court has considered some evidence and has then come to a conclusion but misused the word presume. It is a case where the court has clearly presumed that I have made unlawful, unjust enrichment of myself. And my entire defense is that I have not done anything wrong. I was due this amount from A2.
Yes.
Now it is a specific allegation of the prosecution that both the accused with dishonest intention caused the fabrication of the pay order and demand draft. In this regard, there is no direct evidence on the part of the prosecution. There can be no other person other than accused number one or accused number two who could fabricate the pay order and the demand draft in question, for the reason that the accused number two is the person that obtained the pay order and demand draft in question, while accused number one is the person in whose favor the pay order and demand draft was obtained. Hence, it is a specific allegation of the prosecution that both the accused fabricated the pay order and the demand draft in furtherance of their common intention. It is the argument of the learned advocate for the accused number one that prosecution has not produced any material, much less proof to show any extent to show that the fabrication is in the handwriting of the accused number one. On perusal of the exhibit P3, it gets clear that the entries are in typewritten form, and hence the contention of the accused number one in this regard with respect to exhibit P3 cannot be accepted. On perusal of exhibit P7, it gets clear that the same is in handwriting and the alteration is also done in handwriting. There is no evidence on the part of the prosecution that the altered portion in exhibit P7 is in the handwriting of accused number one. The IO should have sought for comparison of the handwriting of the accused number one with the handwriting in alteration in exhibit P7 to prove that the alteration is in the handwriting of accused number
What
two.
is there for 34 against A1? What knowledge? Not this. Would you rope in? How would you rope in A1 in this case? He might be the beneficiary, Mr. The check, the demand draft was fabricated at the behest of A2 in the account held by A2 in the branch where he was working. What knowledge is? How can you fabricate is what I'm asking. Fabrication should have happened at the branch where this accused number two is working. Correct. You could not have fabricated after you received the demand draft. It is not your case. It is not your case that the demand draft for ₹80 was issued by A1 to A2 and that A2 tampered it as 80,000. That is not your case. What is the charge? Let us see what is the charge.
Let me just just make one more submission on that. That DD for 80,000 was in fact passed by the bank. It has gone through three hands, PW3, PW1, and both said I have seen it and I have passed it due to haste in my work and work pressures. So the entire prosecution is founded on the allegation that I knew.
Let us see the charge.
Very well. The charge is that you, the accused number 1 and 2, with dishonest intention.
Please
So
wait,
that
please wait. The charge on the slip part quickly. Yes.
I so and so ATSMM do hereby charge you the above named accused as follows. That you, the accused 1 and 2, with the dishonest intention, opened a bank account in Syndicate Bank, Kormangala branch in the name of accused number 1, and on 12/6/2001 got issued a deed of in the name of accused and converted the same into rupees 80. So I presume a typographic error, it would have been 80,000. And produced the same before CW1 bank and got the amount drawn to the credit of accused number 1. And similarly on 28/1/2001 got issued a DD for rupees 150 and converted the same to 1,50,000 and tried to credit the same in the account of accused number 1. Thereby committed offence punishable under 468, 470, 420, Reddit 34.
Yes.
In fact, the dates are also wrong. 28/1 is not the date of the second DD, but that also may be left as a typographical error. Can we show it on a reasoning for
Demand draft or check?
demand draft?
Pay order.
First one is a pay order, second one is a demand draft. The Honor has the exhibits. In fact, even the learned appellate court says it is the accused number 1's fault for not going to the bank and verifying what can be seen with plain eyes as a sample document. But if your Honor sees exhibit P7, which is the document that was passed by the bank, which was credited to my account, to a layman, this would not look like it is tampered.
It is tampered.
That's-
It is tampered.
Is a document that I have received from someone who works in a bank in discharge of an obligation that they owed me. I had no
Who was
reason to
tampered?
believe-
Question is who was tampered?
Question is who was tampered as far as they are.
Whether you are tampered it or he has tampered.
It is no one's case that I have tampered. It is their case that I have jointly tampered in any evidence, even the statements of PW1, even the statements of the bank officials, is that A2 has tampered with it with some connivance of someone else at the bank.
Please read the evidence.
PW1 is the senior manager. Ranu will see the definition of PW1. I will not go through the chief examination, Your Honor. It is fairly what they have said in the complaint itself that on the dates on which I have encashed the 80,000 also. Your Honor, see the second page of the chief examination. I'll just show Your Honor the dates on which I encashed the 80,000. The way the demand draft works is the minute I encash it, the entire 80,000 goes to my account. But it is not their case that I have withdrawn it and run away. I have not taken the entire 80,000 at one shot or 1,50,000 at one shot. I have,
Even that 1,50,000 is credited into your account.
no, that was on hold. They essentially waited for me to come back to the bank because they thought it was tampered with. The day I came to withdraw some money, they have arrested me and registered the FIR. That day also, I did not try to withdraw 1,50,000. I tried to withdraw 20,000. But Crown is on the top of the page, the second line, the 80,000 rupees that I was credited to my account, I have withdrawn 79,500 over the course of 1 month. It is not that I have tried to take the amount in fleet. It is for my regular day-to-day activities that I have been withdrawing part whenever I needed money. Now, if I can just go to the cross-examination. I I cannot say who purchased the DD for 80,000 from Jalali branch as per exhibit P8. We had not doubted the genuineness of pre-order. We had not doubted the genuineness of pre-order for rupees 80,000 presented in respect of the account of accused on 25/6/2001. We have not even doubted that the said pre-order was fabricated one. When the bank officials themselves did not raise an eyebrow about this DD, how can I be expected to believe that it was a dishonest or fabricated document? On presentation of DD for rupees 1.5 lakhs, we doubted the genuineness of the same, and thereafter we withheld the payment thereon and inquired with the branch which issued the same. It is not true to suggest that the said DD was honored by that time. It is not true to suggest that we doubted the genuineness of the said DD only when the accused came for withdrawal of the amount of rupees 20,000 on 28/10/2001. I cannot say that the said DD was fabricated by A2 and given the same to A1, and accused number 1 has not fabricated the same. We came to know about the fabrication of DD only on presentation of the same and sending the same to the branch, from which drawn the same for payment. The last line has been cut off.
We did not come to know that the pay order presented on 25/6/2001 was a fake one. We lodged a complaint.
Again, the first DD that was passed, they also did not realize that it was fake until 3 months later when they went back to the inquiry.
From whose account these DDs were drawn? A1's
From
account.
A2 gives the money to the bank, takes the demand draft, gives it to me. I cannot say that the accused was not knowing that the said DD and pay order were fake ones. It is not true to suggest that even if the purchaser of the DD commits fraud in getting the DD, it will not be known to the person from whom the same is delivered. It is false that accused is not having any excuse.
What is your, what was the transaction between you and A1, A2?
The case I put forward is that I entered into a loan agreement with her. I given her about 2.3 lakhs in cash. She was returning that amount through the DDs, for which I also produced the loan agreement.
Where is that?
Exhibit P1. D1, sorry. Exhibit D1 is my loan agreement dated 16/1/2001. There is no cross-examination by the prosecution on this document. There is no cross-examination suggesting that I have fabricated the document. There is no cross-examination to the effect that I cheated the bank in any way or that I had any intention to cheat the bank, any motive to cheat the bank. If at all there was any motive, then it has to be A2's motive to defraud me and the bank by paying back this amount through a fabricated document. But I do not have any motive to have anything against Syndicate Bank. I don't have any grievance against Syndicate Bank or anything to do with them issuing a PD in excess. I have nothing to gain from that. I am only reclaiming from A2 what she genuinely owes me.
And in case the time is also quite not against the complaint.
That is not the issue. Who has tampered this? Then why was the first DD what you call honored? How was the first DD honored? First DD for 80,000. How was it honored? How was it honored? How was it encashed? That was.
PW2 also deposits about it. PW2 says at the time when I made the entry in the computer, it did not come to my notice that the said pre-order was either fake or fabricated one. PW2, PW3 all depose. Both of them say this DD came before me, the pay order for 80,000, and we have passed it. We did not think it was fishy at the time.
Find out what has happened to A2. Find out, Mr. Correct. Please find out what has happened to him. What has happened to her. Whether after the case was split up, has anything moved? Split up as well. Please find out. Verify. The case is proceed registered, then we'll have to remind the matter back to the court for retrial. Yes. Learned counsel for the learned executive directed to ascertain The status of the charge sheet that was put up against the accused number 2. Withdrawn and could you have responded? Yes, Bhagavan. What is this?
Arising out of 138 of negotiable instrument act. The original accused died and his LRs have been brought on record as petitioners.
Accused died.
Accused died. ಅದು ಫೈನ್ ಇರೋದ್ರಿಂದ it will survive ಅಂತ ಆಯ್ತು. So it can be recovered as a fine levy warrant if the judgment is retained. So LRs can come and contest the matter based on the evidence on record.
Yes.
Admittedly, the accused had availed a vehicle finance from the private financier, that is the complainant, who was running a private finance, wherein he had issued 3 checks as security, which is an admitted fact. For that, my lord, there are proper documentations while availing the loan. Due to his kidney failure, my lord, he could not repay, and the vehicles were brought for sale. It's a lorry. 2 vehicles have been sold, and loan has been recovered and closed. But however, the 3 checks, whatever given as security, out of which he returned 1 check. The other 1 check, my lord, he has filled up and presented for encashment. His contention is he demanded a hand loan for his difficulties. Therefore, I lent it without any document. And he has failed to repay. But when I have already availed a loan, which I have defaulted, wherein my vehicles are brought for sale, or the likelihood of the complainant without any document giving 2,80,000 as a hand loan.
What was the loan raised initially?
Initially 3 lakhs.
It's a vehicle loan.
Vehicle loan.
3 lakhs. How much was recovered?
Lord, ಅಲ್ಲಿ 8 ಲಕ್ಷ ಏನೋ ಒಟ್ಟು ಆಗಿದೆ ಅಂತ ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಇದೆ. ಅದರಲ್ಲಿ separate documentations ಇಲ್ಲ. But even the lower appellate court has given a finding that vehicle loan has been completely paid. Internal page number 9, ink page 16. ಮಧ್ಯೆ ನಿಶಾನೆ D1 ರಿಂದ 4 ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 9. ನಿಶಾನೆ D1 ರಿಂದ 4 ವಾಹನ ಸಾಲಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ದಾಖಲೆಗಳಾಗಿರ್ತವೆ. ಸದರಿ ವಾಹನ ಸಾಲವನ್ನು D1 ರಿಂದ 4ರಲ್ಲಿ ನಮೂದಿಸಿದ ಪ್ರಕಾರ ಹಂತ ಹಂತವಾಗಿ ಮೇಲ್ಮನೆದಾರ ಎದುರಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ದಿನಾಂಕ 13/7/2011ರಂದು ಮೇಲ್ಮನೆದಾರ ಎದುರುದಾರಿಗೆ 10,000 ಹಣವನ್ನು ಕೊನೆಯ ಬಾರಿ ಕೊಟ್ಟಿದ್ದು. ಇದರಂತೆ ನಿಶಾನೆ D1 ಮತ್ತು 2ರಲ್ಲಿ ನಮೂದಿಸಿರಲಿಲ್ಲ ಅಂತ ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೇಲ್ಮನವಿದಾರರು ಎದುರುದಾರ ವಾಹನ ಮೇಲೆ ಫೈನಾನ್ಸ್ ಸಾಲ ಪಡೆದುಕೊಂಡಿದ್ದು ಆ ಸಾಲವನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಮರುಪಾವತಿ ಮಾಡಿರುತ್ತಾರೆ ಎನ್ನುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ. ಆದರೆ 2,80,000 ಹಣವನ್ನು ಮೇಲ್ಮನೆದಾರರು ಕೈ ಸಾಲವನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಬಡ್ಡಿ ಸೇರಿ 3 ಲಕ್ಷ ಸಂಬಂಧಪಟ್ಟ ನಿಶಾನಿತಿ ಎಂದು ಚೆಕ್ ಕೊಟ್ಟಿದ್ದರ ಬಗ್ಗೆ ಮುಖ್ಯ ವಿಚಾರಣೆಯ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ PW1 ಮತ್ತು ದೂರಿನಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಫಿರ್ಯಾದಿದಾರರ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ಸಾಕ್ಷಿಯಿಂದ ಕಂಡು ಬಂದಿರುತ್ತೆ. ದಿಸ್ ಈಸ್ ದಿ ಎವಿಡೆನ್ಸ್ ದೇ ಸೇ ಈಸ್ ದಿ ಪ್ರೂಫ್ ಆಫ್ ಲೋನ್. ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಪಾಟಿ ಸವಾಲ್ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಅಂದ್ರೆ he has not replied the legal notice that is taken as an exception by both the courts to hold.
Ravi Kumar, MD Ravi Kumar. There is no representation for the respondent. If there's some settlement in this, what happened? Yes, what is it?
332. both are under police constable. The between the parties, it is settled. In fact, 332
Why don't you impose some fine and close it? 332.
is imposed.
So we'll hold that conviction is proper. We'll impose some sentence and close it.
Both are public servants.
You're still serving.
Yes, no, I have now dismissed from service in view of the conviction. If the conviction is upheld, the de facto complainant has come forward and settled it. But they have filed his affidavit also. Both of them are present before this court.
Yeah.
Both of them
are employed in the department.
Both of them are employed. Both of them are working as constables. One, the de facto complainant was head constable. He has just retired. The accused, the petitioner is constable. That's the only allegation is that due to certain difference of opinion between them, the allegation is that they have held his collar and pulled him. No allegations of grievous hurt or obstruction to duty or anything.
332 years of obstruction to duty. For what? What did you obstruct? Obstruction is regarding what? When you obstruct what? Saying what? What is the allegation? Please read the allegation. Yes, Mr. Pratish, what is the allegation?
The allegation is that the head constable and one other person had given a report against the accused, due to which I was placed under suspension. Thereafter, I was reinstated. Now, the allegation is after I was reinstated, I have called the de facto complainant and held out a life threat. Thereafter, on the same day, I have gone to the police station. I was reinstated back to the same police station. Both of us were colleagues. The allegation is that around 10 p.m. in the night, I have held his collar and pulled him and abused him.
Person has to be restrained from doing his duty or obstructed from doing his duty. What is that duty that he obstructed? To maintain a charge under 332. Suppose if he is writing a report, he's writing some report, you go to the police station, catch hold of his hand, stop him from writing that report. That is obstructing his discharging his duty. What is that duty that he obstructed? To maintain a charge under 332. That is not the issue. The moment he went and got him hold of his collar, by his collar, was he discharging any public duty? Did he restrain him from doing any public duty? And then 332 inverse. How is 332 maintained? Whoever. Where is the allegation that the obstructed him from discharging his duty?
After evening,
Was he discharging any duty at that point in time? For example, he goes to arrest him. Arrest Manakoda Warrior. That I can accept. Suppose he goes to serve a warrant, you assault him. I could now they want to compound.
Have taken the ground Malad, in the division that the lower appellate court, Malad, let alone discussing whether he was on duty, does not even say Malad, whether he was on duty. There is no discussion on that at all, Malad, with the lower appellate. The trial court also says Malad, that does not discuss whether he was on duty. There is not even a straight sentence on whether he was on duty or anything like that. And the 320 Malad, 332 is not compoundable, but 323 is compoundable. That's one way of looking at it, Malad, is that it can be 332 to 3.
You file a 482.
In a criminal revision petition, when Malad, after conviction, Malad, when the matter is settled, this court has exercised power, Malad, compound the offense.
Yes.
I just place
You want in 332, please show.
I'll place that one. So, first two. I'll leave out the first two judgments because they are judgments of the Supreme Court. Would your lordship be kind enough to turn to page 15 minutes? This was in a criminal revision petition. Let's at page 52, paragraph 2 minutes. Offense was 504, 323, and 326. Here again, Malad, the offense was compounded. The parties had entered into settlement after conviction in a criminal revision petition. This all court, Malad, relying upon two other.
Division court can definitely call.
320, yes. I'll straight away come to 320, 332. Yes, sir. Would your lordship now come to page 73, Malad? Page 75, Malad. The offense is on top, 323, 504, 506, 353, 332, 382, read with section 34. Plus again at page 78, since it was the parties had settlement, it was compounded 78. Page 80 is the second judgment. 82 are the offenses. Section 143, 147, 323, 332, 353, and 504.
After Jansing, there's one more judgment.
I have produced that that is the latest judgment in Ram Gopal and another one.
They reconsidered Jansing.
Yes.
Where is that?
That's right. Page starts at page 42, Malad. 42. Page 42.
Page 42.
Yes.
Yes.
Let's hear two appeals went, one from Madhya Pradesh, one from Karnataka. Here, Malad, there was an order of conviction which was confirmed. Thereafter, Malad, revision petitions were filed before this honorable court, Malad, seeking for compounding the offences in view of the settlement, page 42. Insofar as the page 43, Malad, para 4, this is relating to the judgment which went from this court. para 5 and 6. my lord.
Not necessarily, come to para 19.
Yes, they reiterate para 12, then my lord 15 and ultimately at para 19 and 20. Para 12, my lord, may be the finding, my lord. Page 45, para 12, my lord.
Yes.
The High Court, therefore, having regard to the nature of the offence and the fact that the parties have amicably settled their dispute and that the victim has willingly consented to the nullification of criminal proceedings, can quash such proceedings in exercise of its inherent power under section 482, even if the offences are not compoundable. The High Court can individually evaluate the consequential effects of the offences beyond the body of an individual, and thereafter adopt a pragmatic approach to ensure that the felony, even if goes unpunished, does not tinker or paralyze the very object of administration of criminal justice system. Now look at para 15, given the para.
Please come to 19.
Yes. We thus sum up and hold that as opposed to section 320 of CRPC, where the court is squarely guided by the compromise between the parties in respect of offences compoundable within the statutory framework, the extraordinary power enjoined upon a High Court under section 482 or vested in this court under article 142 of the Constitution can be invoked beyond the metes and bounds of section 320. Nonetheless, we reiterate that such powers of wide amplitude ought to be exercised carefully in the context of what is proceeding, bearing in mind nature and effect of the offence on the conscience of the society, seriousness of the injury, if any, voluntary nature of compromise between the accused and the victim, conduct of the accused person prior to and after the occurrence of the purported offence.
So we have to point out whether a non-compoundable offence could be allowed to be compounded in a revision.
That is why, Malad, I pointed out, Malad, the page number 50. If this was a revision petition, insofar as non-compoundable offences against a conviction, Malad, the offence was compounded, page 50, Malad. The only distinction here is, Malad, 332 was not involved in this revision, but it was, Malad, non-compoundable offences in revision allowed to be compounded. Page 50, Malad.
That is, if it is purely between two private individuals.
Yes, Malad.
Virtually against the state.
This is also between two private.
332.
332.
Public duty.
Malad, both are public servants. There is no finding, Malad, by the trial court that he was in discharge of public function. May I just take your lordship?
Were you convicted for 332?
Yes, Malad.
Then
332, 504, 506. May I just take your lordship to page 88, Malad? Malad, reference was made to the division bench of Punjab and Haryana High Court, Malad, as to whether the offence under 332 is compoundable. Page 88. Page 88. Malad, page 89. The first paragraph, Malad, page 18. The petition has come before us on a reference being made by the learned single judge regarding quashing of FIR on the basis of compromise for offences against police officer under section 148, 149, 332, 353, 186 and 506 of the Indian Penal Code. They refer to the learned single judge's order, and Malad's question is framed at page number 94. Para 8. We have perused the reference made by the learned single judge and are of the view that there is an inadvertent mistake in formulating this. So we frame the question, we answered by yes, which is whether the offence under 356, 186 and 332 of the Indian Penal Code against the accused petitioners can be.
Was this in a revision petition?
Yes.
Was this in a revision petition?
This was a reference made, Malad, in CRM.
Correct, but this reference was arose out of a petition to section 482.
Plus there, Malad, it was a 482 because it was at the stage of FIR. Now, Malad, the answer by that, Malad, to that question is at page 95, Malad. 95 para 9. The extent and sweep of inherent power exercisable by the High Court under 482 of the Code of Criminal Procedure for quashing the criminal proceeding on the basis of compromise between the accused and the victim of crime in cases which are not compoundable under section 320 or 321 of the Code has been considered in extenso and answered by the Honorable Supreme Court in Yansing's case, laying down that compounding of offence and quashing of criminal proceedings are two separate things and not interchangeable, and that the two powers are distinct and different, although ultimately consequences may be the same. It has been authoritatively ruled that where the offender and victim have settled their dispute, the High Court, in exercise of its inherent power under section 482 CRPC, is competent to quash criminal proceedings, even relating to non-compoundable offences,
though such power needs to be invoked sparingly and not when the offences are heinous, serious or mental depravity or like murder,
Please
rape.
explore the possibility of invoking 482.
In a revision petition, as against conviction, revision is the only maintainable. Here, while exercising power under revision, offences can be compounded.
Correct. Not in respect of a non-compoundable offense.
It has been exercised. May I persuade you?
Here judgment note that.
Yes, page
Seen those
50.
two judgments, but
Yes.
then again, that is in reference with to Janssen.
No, page 50 is with reference to two other judgments. Page 15. May I just take the lot of page 50. 51. Because the prayer there is noted. Page 51.
Yes.
The criminal revision petition is filed under section 397 read with 401 of CRPC, praying to set aside the judgment of conviction dated so and so and order of sentence dated so and so, passed by senior civil judge so and so, and set aside the judgment and order dated so and so, passed by principal district and session judge Chikmagalur in criminal appeal number so and so.
So find out.
Complaint filed IA number 1 for 18 under section 480.
I have also filed IA number 1 under 480.
Love the thing of the state of Maharashtra. Very clearly description about camping case and other.
Hence, if it against other than the extension of the state, then 195 of CRPC will come. That can only be, they'll have to file a complaint with the permission of the government, with the head of the authority, and then in the name of the government.
Yes. What about 401? Can we 401 can we invoke 401 and can invoke the powers of the appellate court under 386, invoking 401 and close the case? No, dear, please verify. Please check 401 and also look at 386.
In case of any proceeding, the record of which has already been filed by itself or is otherwise complete, the High Court will in discretion exercise any of the powers conferred on a court of appeal by section 386, 389, 390, 391 or on the court of decision.
If we still have the powers of a court of appeal, then maybe we can apply the law laid down in Janssen. Close it. Hold it, check money. Then tomorrow. Yeah. Friday. Yes. Any urgent matters?
Serial number 5, my lord. Serial number 5. Filed
Not
memo.
run with her, please. Have some patience. ಹೇಳ್ರಿ ನಿಮ್ದು ಹೇಳ್ರಿ.
Number 5, filed withdraw memo.
Number 5. You seem to be in a very great hurry. A picture ಹೋಗ್ಬೇಡ.
There is JC, my lord.
Picture ಗೆ ಹೋಗ್ಬೇಕು. Movie, you want to go to a movie. See number 5. You filed a memo to withdraw.
Today.
Mr. Alonso has entered appearance for the respondent. Office is directed to show the memo so and so. As the counsel for the respondent. A memo is filed by the Royal Council for the petitioner to withdraw the revision. You have to say about petition.
Petition is JC, my lord.
The petition you want to withdraw. You paid the money.
Sure, entire rate.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ಲ. Please have filed a memo to withdraw. The respondent counsel has not signed this memo. So you have to sign the memo and say that you received the entire money. The joint counsel for the petitioner and the respondent have filed a joint memo stating therein that the petitioner has paid the entire fine amount. Entire fine amount. And fine amount as ordered by the trial court. The CC numbers also. And therefore prays that petition may be dismissed. This copy, however, contends that the respondent, the petitioner is in judicial custody and therefore appropriate order to be passed to forthwith release him. Next paragraph. The learned counsel for the respondent does not dispute the above fact and has no objection for release of the petitioner. In view of the above, the respondent is ordered to be released. Sorry, in view of the above, the respondent is released. The order to be released. If he is arrested pursuant to any warrant of arrest issued by the trial court to execute the note of sentence dated so and so, CC number so and so. Pass by so. Come tomorrow. Come tomorrow at 10:30. Could you memo? Could you? So you should have some patience. Don't irritate the court. One case ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತೀರಾ. Hello, listen, ಹೇಳ್ರಿ. ಇನ್ನೊಂದು ಕೇಸ್ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತೀರಾ. ಪಾಪ ಅದೇ ಬೇರೆ ಲಾಯರ್ಸ್ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. Because of your irritable character. ಅವ್ರೇನೋ ಹೇಳ್ತಾ ಇದ್ರೆ ಅವ್ರದಿಂದ ಮುಗಿಸಿಲ್ಲ ನಿಮ್ ಮಧ್ಯದಲ್ಲಿ ತೋರಿಸ್ತೀರಿ. Stop this habit. You're not the only important lawyer in this court. Oh, yes, madam. Yes. Yes, Mr. Now, the last state we have stated that they are residing outside. Now, ನಾಳೆ ಹಾಕೊಳ್ಳೋದಾ? He will exempt them from personal appearance before the court. And the permanent exemption. Tomorrow, if you raise a red flag in the immigration, they can't go out of India for information. Out. To serve an NBW, there is a process. It takes 6 months. Therefore, don't worry. The request was done. The this one. 30th. 30th. Then please ask him, he will give, madam. Please ask him. Yes, yes, madam.
We remember 77 million.
75.
77.
What do you want?
77 million. Matter
That is settled.
has. I'm very for the petitioner in the government.
If you want to make this revision petition is well challenging this concurrent judgment. Convicting the petitioner for the office punishment of section 138 of the negotiable instrument act. The petition was listed for admission, comma. The petitioner as well as the respondent have filed a joint memo in terms of which, comma, they have settled the dispute at a sum of rupees 20 lakhs. Where have you mentioned? Huh? You filed the affidavit in the office, but you should mention that in the joint memo, Mr.
Joint memo, and they have on the what, they have submitted. They have filed.
Huh? What application? 451 for what? 147, Mr. You should file the 147.
File application for release of the amount that matter has been settled between the parties.
Correct, ma'am. If you want to withdraw the revision petition, you file it. If you want to settle it, you say what are the terms of
Matter
settlement.
has, that's why I have filed joint memo.
The joint memo, you are not mentioned what is the amount that is settled?
Matter has.
Where have you mentioned? Why don't you mention that in the joint memo, Mr.? Why don't you mention it in the joint memo? Where is our tarikh? You have mentioned that you will settle the dispute at 20 lakhs. Why don't you mention that in the joint memo? Please file it tomorrow. Tomorrow. Yes, Rajan. File an application. File an application for extension of time. Illegal. Put up agilwala ye. Ye put up agile note. Yes, yes, Mr. Huh? 65 tomorrow. Tomorrow. I party is in it tomorrow. 55. This is tomorrow. Yes. What is that? How old are you? How old are you? Not you, you are playing. Accept notice for the respondent. If the petition is convicted for the offence under section 304A of IPC and it is represented that the petition is only breadwinner of the family. IA 1 of 23 is allowed and the thought of sentence that is also passed is suspended. Yes.
Yes.
Yes, 71. Clear? What do you want? This is the extended. It will not be extended. Yes. Number? Notice regarding it. 50%. Yes. including the amount already deposited. Yes, Mr. Mohan. 27. Passed over.
Yes. I just went outside and not.
Discount. Do we have- Ah. 37. ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ ಏನ್ ಮಾಡ್ತಾರೆ nobody is interested to clear old cases ಏನ್ ಮಾಡುತ್ತೆ maybe all of you think I am rigid ಏನ್ ಡೇಟ್ ಕೊಡ್ರಿ ಎಲ್ಲ ಕೇಳ್ತಾರೆ ಹಾ ಹಾ ಏನ್ ಮ್ಯಾಟ್ರ್ ಅದು 2014 ಬಿಡ್ರಿ ಪ್ರಸಾದ್ ಅಲ್ಲ ಅದು ಹಳೇದು ಹಳೇದು ಟ್ಯಾಕ್ಸ್
Eighty-six or last. Eighty-six. See number 86 or last. Externment proceeding. Externment proceeding. See number 86. Externment order is there. I have been externed. I am the only breadwinner, my mother and my wife and children.
Number
86 the last case. I am the only breadwinner.
I think you come maybe tomorrow, day after tomorrow.
Tomorrow, please, tomorrow.
ಅದೇನು ಕೇಳದಲ್ರಿ ಇದಿಲ್ರಿ ಅದು ಕೊಡಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಕೊಡ್ರಿ ಅದು issue notice to the SCGP is there to accept notice for respondent number 1, issue emergent notice to respondent number 2, interim stay of further proceedings in CC number so and so on the file of so and so. Yes.
Sir, serial number 72. Sir. ಸರ್ ಹೇಳಿ ಸರ್ ಇದ್ರು ಸಾಹೇಬ್ರು ಹೌದು ಇದ್ರು 72 ಏನಾಯ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 72 ಏನ್ ಮಾಡಿದ್ರು ಬರ್ಲಿಲ್ವಾ
Court officer. Volume mute ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ court officer. Court officer.
ಮೇಡಮ್ ಹೇಳಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 78 ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. ಯಾವತ್ತ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
27th January.
ಆ
27th January.
78 ಐವ
madam,
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರುತ್ತಲ್ಲ?
ಅದಿಲ್ಲ ಮೇಡಮ್, ಬರೀ ಡೇಟ್ ಅಷ್ಟೇ.
ಅಲ್ಲ ಬಟ್ ಐವ ಇತ್ತಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್ ಅದು.
ಓಕೆ ಸರ್ ಆಯ್ತು.
ಇಲ್ಲಿ ಯಾವ್ದೋ ಒಂದಿದೆ ನೋಡಿ.